Hello, Jake. Hello.
Hey, Clint.
How are you?
Good, good. How are you?
I'm fantastic.
Awesome. It's my first time on one of these calls.
Wow. How'd you hear about us?
Well, to another forum, who said that they used Commoner Law Group to push back against the vaccine mandates at their work. They had done a very nice outline of basically what they did, how they fought back. And I unfortunately found out about common law about 2 weeks before I was let go. So I might have been able to put something together, in that quick of a time, but unfortunately I just didn't get my act together. And so they fired me back in April. And, I have started a case through a law firm to do an EEOC complaint, but I'm not super confident that that's gonna, get me where I want to be. But the whole point here is just to fight back against my former employer, because they, clearly overstepped their bounds, as many companies are doing. And, this has become a personal battle now.
Great. Well, I'm glad to have you. That's the spirit. That is the spirit. I was heads down myself developing the course we're introducing today and just looking at all of the things and strategizing for everyone as best we can. And I just lifted my head up for a minute and I said, I can't even believe we're here. Like, why is this even happening still? That we should be have to defend ourselves against our employers mandating some sort of experimental injection. Is just beyond belief. So we have to fight back on so many levels. We have to fight back because we have
100%.
to stop this attitude, this idea in America, the country that is the freest country supposedly in the world, that we have a tradition of natural rights and God-given rights. That's the foundation of our nation. So we've learned a lot, though, Jake, since last time. So it's just as well, perhaps, that you joining us now, and welcome, double welcome.
Thank you.
Yeah, let's say hi to Nancy and Sin. Is it Sin or Chin? Brad and Jonathan's here as well.
Yeah, hi, how are you?
Hi, welcome. Yes, thanks for coming earlier. Just want to spend some time getting to know each other maybe a little bit. I've got a couple of videos that I want to share with you folks that, for me, indicate that the tide is moving in our direction, that the public opinion, as well as legal precedents, are heading our way. And so this could be good timing. But if you have some good news, anyone who's here, like whatever good news you may have heard recently in terms of what you see as a breakthrough for we the people, breakthrough in not having to have to believe the idea that other people can tell us what to do when it comes to our medical treatment. So it's a big deal. It's been going on for a long time. If you haven't met me before, you'll need to know that I've been fighting health freedom issues for at least a decade. And I focused a lot of my efforts in the first many years on countering the fluoridation of our water supplies, our community water.
Are you a lawyer?
I am not a lawyer. No, I am not a lawyer. And the cool news is you don't have to be a lawyer. I'm working with folks, specialists who've been studying the law from a variety of points of view, common law, but of course statutory law as well. And what we find out is that it's not as hard as they want you to believe. They love lawyers, bar certified lawyers and judges would love for everyone to believe that it's really complicated. It's over, you're in over your head. And so don't even try, hire a professional and they'll take care of you. But then they run you through the system. They run you through the ringer. Lawyers I'm going to spend a little time on today's introduction, if we have time, giving lawyers a black eye, because I don't really think that they're our friends on the whole, in general. So that's why the Commoner Law Group exists. It's to train and coach ordinary people in the principles and practices of law sufficiently so you can manage your own affairs. And even if you do end up hiring a lawyer, you'll be more empowered. You'll be able to keep them on a short leash, if you know what I'm saying. So welcome. Yeah, we're getting to know each other here. Hi, Jonathan.
Hello.
Hi, Nancy. Hi, is it Chin or is it Sin? Shep.
Sorry, it's Sin.
Sin.
Yeah, sorry about that.
No problem. Is it?
Hi,
Hi.
I'm totally brand new to this. I'm even more confused because normally I live overseas and I'm used to Napoleonic code, and I'm like, how I want to find out how I can do this. How I can back out of a lot of things, the documents, everything. So this is me being very new at it.
Well, good. Welcome.
And preventatively for my daughter, who was required to put a, what do you call it? I can't remember the name of the form, but she had to justify not taking a vaccine with an exemption. And I'm
Sure.
understanding there's a problem. So all of this for me is very new. So
Good. Well, welcome. You're in the right place.
I'm probably here more in a listening capacity because I have no idea.
Well, that's all right.
Thank you.
That's fantastic. Yes, thank you too. If you want to say hi, Nancy, go ahead. Okay, so yeah, there's been a lot of court cases. I don't know how much you all are following. There's just almost too many to follow now, which is great in the sense that it's like the dream it's a dream to me, a vision I threw out there last year that, we can imagine an America where we, the people, are empowered enough with the principles and practices of law sufficiently to go into court, and that we're doing it in the hundreds and thousands across this land, because we just have to shift the whole paradigm where only a few cases make it to court. Only again, lawyers are able to bring those cases, and they're expensive, right? That's like the number one obstacle to hiring a lawyer or working with a law firm, is that it's prohibitively expensive for most people. So if we're to have justice, if we're to know ourselves as a just nation, then we, the people, need to be using the justice system a lot more. And again, it's not that hard. Of course, there's huge complexities when it comes to the law. You have civil law, you have criminal law, which are two different worlds altogether in terms of how those proceedings unfold and what it takes to win a case, and who are the parties involved and that kind of thing. And then you have all kinds of specialty law where lawyers are trained to do, trusts or investments or property law, real estate, all kinds of specialty business areas where lawyers spend their entire careers. And those folks, from what I understand, are, they're good, hardworking people. You get the value for what you pay for, because they're helping you with your personal affairs, like your real estate investments, for example. But when it comes to someone breaching a contract, and that's where we're going to go today, we'll say a lot more about it during the introduction. The civil proceedings allow for you to sue people who have breached a contract. You had everyone who was employed had a contract, whether it was written, whether it was verbal, or whether it was implied. So all you have to have is a pay stub, and that's proof that you've had a contract. So that part is clearly stipulated. That's easy to prove. The other two elements of your civil suit, as well, again, I don't want to say everything because we'll just be repeating it later. This is a time to get to know each other, but there are two other elements. You have to prove that there was a breach of contract and that breach caused damages. So once you prove those three things, and it's very straightforward to do that, then you get an order from the court to pay damages.
What were the three things? Breach of contract, the breach of contract caused damages. What was the third thing?
That was it. That's it. That was the third thing. So the breach itself, and then the damages caused by the breach is the third thing.
Yeah. Interesting thing about, I noticed one of our callers here just mentioned religious exemptions, and wouldn't like to go the route of exemption. And I resonate with that. And
I would like not to use those exemption forms, hoping to learn not needed and to take them to court. Okay. That's Nancy.
Yeah, Nancy. And interestingly enough, the California statutes do allow a protected class for religion and creed, and of course, medical reasons. And I think, you know, I wonder if that's ever been really used, because such a mandate, right? If you say, okay, you file for a religious exemption and I file for an exemption, and then they say, well, you don't belong to a church, denied, or right. Now, any religious exemption that can be denied means it's not a religious exemption in essence, because I'm telling you it's my creed, but you're then denying it. And it,
Wow,
it
you get
almost
right to
seems
the
like,
heart of the matter. Jonathan's perfect.
I mean, it almost seems like that alone, a court case or two alone, challenging that very thing could destroy the mandates altogether. Because then there's no use having a mandate if people can automatically say, oh, look, I just don't want it, I don't believe in it. Then there is no mandate, right? That's,
Fair.
you know,
But
and
your fingers
hopefully
out.
we can do that, you know, and that might be a route. I'm not sure.
Well, we're going to find out. And the thing is, as much as I would love to have, you know, vaccine mandates of all kinds just uniformly struck down across the world, that's not actually what we're up to here. Each and every one of you is going to have your own path. We're going to go. I don't want to take, again, I don't want to say too much. We have the top of the hour coming up in 15 minutes. So let's just get to know each other a little bit. But what I wanted to do is just offer an opportunity for people, one, to come early and hang out a little bit, you know, say what's going on with you, or take a look at these couple of videos that I have to share with you that seem to indicate that the tide is turning in our favor, which, you know, some people kind of predicted, in the sense that the truth will always come out. Right? The truth will always come out. So I don't know if this was actually a little while back but I still consider it relevant and newsworthy. Let's see if I can get a screen share going up here. And
Yeah, I want to hear some good news.
You want to hear some good news? And it's right up your alley, Jonathan, in terms of what you're talking about, religious exemptions. So let's see, is everyone looking at my screen? The government has tipped their hand.
Yes.
Okay, great. So
Yes.
I'm just
When
gonna,
did this come out?
Play the clip, the human events, Posobiec clip. Let's play the clip and we'll come back to Jack Posobiec.
Listen to what this DOJ lawyer had to say about religious exemptions when it comes to the issue of abortion.
Cases. And for instance, in the New York case that's currently going on against the state of New York, the Thomas More Society is representing a bunch of doctors and nurses who claim that they would sin gravely if they acted in cooperation with the evil of abortion. How would they be doing so? The claim is that all three of the current vaccines either have fetal cells that were obtained by abortions in the vaccine itself, or in the case of Pfizer and Moderna, that those vaccines were tested using fetal cells that had been aborted. And even the connection to the previous testing makes them cooperative with evil in a way that their religion prohibits. I don't want to say anything too categorical, but I believe that when this claim will be very difficult for agencies to successfully claim that that's either insincere or non-religious. Even if it is, even if we know that many of those claims are not sincere or are sincere but not religious, this is the most common claim you're going to confront probably. And it's likely that you will have to take as a given the employee's claim. Not always, right? One response that some hospitals have started to give is, well, do you know that Tylenol and Tums and Preparation H, those were all tested using aborted fetal cell lines too. And I expect that employees will then say, well, I didn't know that, but now. There is a compelling interest, obviously, in keeping our workforce and the public with which we interact safe from COVID.
So
Okay, that's kind of blockbuster. Tell me what that is. How you got it, and what's the implication of that?
Screen there, that's a White House
internal phone call where a Department of Justice, lawyer by the name of Marty Letterman. This is a white hot story. The White House is gunning for me. This is why they're after my sources. They're after everything that I'm going out because I've got a White House insider, a whistleblower, basically, who has leaked this audio to me of Marty Letterman at the Department of Justice saying, and you could hear him saying this, that even though he knows that these vaccines, the Moderna, the Pfizer, and of course, Johnson & Johnson, were involved with vaccine testing that was done on fetal-derived, abortion-derived cell lines, that he thinks that many of these claims are not religious-backed and not sincere. Marty Letterman at the Department of Justice thinks that it's his decision to determine what your religious beliefs are. If you're in the Christian community, if you're pro-life, he's telling you what your religious beliefs are, and then he's looking for ways for the agencies to be able to get around this. So you understand what they're doing. They're not talking about, hey, how do we make sure we accommodate people's religious practices? How do we uphold the First Amendment? No. He's looking at this from a perspective of how do we crack down and impose these mandates on the federal workforce? And mark my words, this will go in for contractors as well. And if they are able to impose this with contractors, the next thing they're going to do, it's not just going to be airline employees, it's going to be airline passengers, it's not going to be retail companies, it's going to be retail customers.
Correct me if I'm wrong when I listen to this. And by the way, this is.
Okay, so what do you guys think about that?
Wow. Yeah, I mean, what is religion? You know, what is a creed? You know, California allows for creed, comma, religion. You know, it boils down to that, and they want to be able to not deny people, get in people's heads, right? And say, you're not religious, you're not sincere. I mean, what's the test for sincerity? I would contend getting fired for your job, getting fired over it, a job that you want, is a pretty good test for your sincerity. So by it, tautologically, by its nature, you're sincere.
Exactly.
You know.
Exactly. So the difference of what you're going to hear about today, later today, in a few minutes, we're going to get started with the introduction, is that all these religious exemptions and attempts to get religious exemptions. Some people applied for the religious exemption or medical exemptions, others did not. Tried to stand on their natural rights. The truth is that you have not had a hearing. You haven't had your day in court. So each person is different and each situation is different, and you are going to have your day in court. If your employer doesn't settle before trial, you are going to get to actually test this theory yourselves. So and again, the facts of your case might be perfect, and they might, maybe they have you on record saying that you don't believe you're an atheist. I don't know. Everybody's situation is different, so there's no formula like that. But the truth is that no one here has had a hearing in court. The best someone might have had by now is a response from the agency, the regulatory agency that protects these protected classes. People of religion, race, creed, sexual orientation, gender. Every jurisdiction has a different list, but that's what we're going to be testing. That's what we're going to be testing. Okay. So then, so the whole question of sincerity is what they want to try to get you on. But in the end, if you haven't had a hearing in an actual courtroom with you bringing the facts and the law to bear, and see what happens is, we'll hear more again about this during the introduction, you're ultimately forcing them to prove that you're not sincere. And how are they going to do that? So I want to show you another video that came out that is pretty helpful, I think, there's a lot of stuff coming about the science, right, and how we were misled in terms of whether it can spread the disease or it can protect you from catching the disease. And now they're saying, well, it only helps people survive COVID with a slightly better chance of dying than if you didn't take it. So they've really, dialed back their claims about what's possible. So let me see if I can get this other video up. This is a perfect example.
So I represent Brooke Jackson, who is a whistleblower who exposed that the Pfizer clinical trials were riddled not only with error, but with fraudulent and false certifications to the U.S. government. That's the allegation of the suit.
Allegedly.
Yes. Well, she's got a lot of evidence of it. But what's fascinating is Pfizer has moved to dismiss the case, and their grounds to dismiss, as they repeated in the scheduling conference we had this week, is that it doesn't matter if they submitted fraudulent certifications to the government. It doesn't matter if they submitted false statements under penalty of perjury to the government. It doesn't matter if they lied about the safety and efficacy of these drugs mislabeled, in my opinion, as vaccines, because the government was in on it with them. The government knows what's going on, and the government still would have given them the check anyway. So is it really fraud if the government's their co-conspirator? That is, in essence, Pfizer's defense so far to the case. So it'll be an interesting case. The judge said that we would be entitled to discovery about any issue related to the motion to dismiss. And so that covers some territory.
That's an interesting thing. In Quebec, last time I checked, if you make a motion, anytime you file a new affidavit in support of a motion, you get to examine on the affidavit. So if they filed a motion to dismiss, basically saying, look, we're innocent, but even if we're guilty, they authorized us to do it. Do you not get to examine them on those new allegations, which were not part of the original proceeding and are new to the file? So
that's what the judge said. Judge said we're entitled to discovery on those issues, which they were going ballistic about. They kept saying, "Oh, well, we've just moved to dismiss." Motion to dismiss is on the four corners of the pleadings, not their motion to dismiss.
Well,
their motion to dismiss includes a bunch of extra extrinsic information, documentation, and testimony, which we're absolutely entitled to contest and dispute and to get discovery concerning. So the court recognized the same, very straightforward, old school judge. He was talking about when he first saw some federal rules, he thought that they were communist back in the day, 30, 35 years ago, but because they really work well, and it involves, disclosure and discovery in a timely material way. So they'll be able to limit some discovery, but not as much as I think they wanted to. And it was a fascinating defense to say, yeah, maybe we lied, but even if we did, it doesn't matter because some high-ranking government people were in on the lie. I don't think that's going to be a defense the court's ultimately going to buy, but it entitles us to discovery in the interim. So it's going to be Brooke Jackson's case marches onward, probably the biggest whistleblower False Claims Act maybe in the history of the United States.
So what do you make of that, folks?
I'm Googling it right now, actually. Brooke Jackson. Oh, right. Yeah. Okay. Yeah. This was from, interestingly, a little while back. That's the same person that blew the whistle on some bad practices at one or more of the Pfizer sites.
Exactly.
Hey, Clint, when we officially get going here, are we gonna have time for question and answer, or should we do that now? Or? Okay.
Absolutely. We'll have lots of time for question and answer.
You know what the good news about this I see is that when you start to really examine scientific results, like say for a vaccine efficacy and so forth, you might have come up with that, yeah, I mean, the vaccine's helpful or blah, blah, blah. But really being very concrete and dotting all the I's and crossing all the T's on a concrete scientific statement about even something like vaccine efficacy, which can be easily said, it is not easily done. And when you put scrutiny to it, yeah, you'll find some holes and you'll find some crap like went on at this site. They want to force it on people, right?
Well, the thing is, what I thought was important about it was not just another claim that the science was phony, that it was bad science. It's not just, is this good science or bad science? What I took from this is that that Pfizer and the government are no longer as cozy as they have been. That Pfizer's feeling the pressure, and their lawyers, the only defense they could do is say, well, the government told us to. And now we've got the government and Pfizer dividing, this case is pitting them against each other, which is really good for the people.
Yeah.
Who knows? And then more could come from that division between them, because they're rats, they're criminals. They don't have any principle. They're just calculating. And when they calculate that the best thing for them is to throw their former ally under the bus, they might do that. And we want to see a lot more bus throwing under. So that's why I brought forth that video, and I just put a link to it. I'm going to put the link to the one we watched also a minute ago, if I can find that link real quick. But if you also saw in the chat, I put in a Black's Law dictionary definition of creed, which is interesting because it resolves to religion, it seems. So when you see religion in your statutes and you see creed in your statutes, you can use them interchangeably. Okay, let's get started. All right, so it is top of the hour now.
Hi, Clint. Thank you so much for doing this. I'm sure there's a lot of us out there. We're really excited, so thank you.
Oh, you're welcome. Thanks for saying so. Time's going to go pretty fast, so buckle your seatbelts, get out your notes, maybe even open up your computer if you want. There'll be a chance to you can even start going online and doing some work today. So welcome everyone. My name is Clint Grease. This is the Commoner Law Group's introduction to our new course, #GoToCourtLegal. If you've been with us for the last year, you know that we've been in the trenches with you, fighting the vaccine mandates as a condition of employment or as a condition of attendance at school. So also everyone who has been kicked out of school, you're welcome here as well. We'll primarily be talking about employment, but the same principles apply to you. So yes, a year ago, we jumped into action because a number of our students were facing vaccine mandates. And it just so happens, it was in San Francisco where the first municipality put forth these mandates. And we were dedicated to using the common law approach. We didn't know what would happen, and we did know that people were absolutely furious about what they were doing. They were clear in their hearts that what was happening is not right, that it was not complicated. All of the justifications that people used about the importance of community health were not swaying us. We didn't see the emergency, and we didn't see that these draconian efforts to get us to do all number of things, from wearing masks, social distancing, taking routine tests, or staying at home, all the things were not justified. And we knew it in our hearts, and we wanted to do something about it. So what we did was we initiated a whole program dedicated to fighting based on the common law. And I'll just tell you, after months and months and months of trying, the ultimate results at this point are that most people weren't, well, I'll start with the successes. The people who succeeded were the ones who kept going, the ones who put forth their documentation to their employer, and they did it with such conviction and they did it with such confidence that the employer made informal exceptions for those people. So there was never a day in court. They never admitted that it was wrong to make the mandates. They just realized that they were dealing with somebody who wasn't going to give up and wasn't going to let them off the hook. And just as we're seeing today, the tide is turning, and they maybe saw that a year from then, they would be embarrassed to have been on the wrong side of history. But for whatever reason, it was psychologically, mostly you could say, and that's how they won. As far as the legal proceedings are concerned, the courts were very across the country in various different courts. They were very reticent to accept a common law filing for a case because we didn't fill out their forms and go through their myriad of procedural steps that you have to go through to get a court case. But we didn't stop, and we anticipated that. So we empowered our students with avenues to challenge the county clerks and get them filed. So indeed, some people were successful in getting their cases filed, and they got their hearing. They got their time in their day in court. They got in front of a judge, and in 5 different cases, they all lost. The judges were unsympathetic. They didn't consider the merits the way that this filing was done to be adequate, and and in some cases they also used the opportunity to voice their own personal opinion about, for example, in San Francisco, firefighter avoiding a vaccine, considering how he interacts so closely with the public. So yeah, we don't know what's really in the minds of these judges, but we did learn so much. And I personally have been in recent months trying to figure out a way, trying to find a way to serve you folks, to have justice be served. I am not a purist. Common law is indeed the law of our land. It is the foundation. It is the foundation of our nation, and we should hold it with great respect and pride and sanctity, because it is God's law. We, the people, are God's creation, and we don't need government telling us what to do. And as well, other people aren't allowed to infringe on our rights either. And the government's number one job is to make sure that doesn't happen. Well, of course, that's changed over the many, many, many years, and particularly in the last 20 years, when common law proceedings have been almost made illegal, in the sense that the rules of court across this land, almost as if there was an agenda, have lessened and lessened the various avenues that we the people have to use the courts in just a common law way. So guess what? That brings us to today. And we're going to meet Zeke Lehman, and he's going to tell you his story, but it's just like my story. It's going to be like so many people's story, that we tried the common law approach, so to speak, and we tried to avoid getting trapped in their jurisdiction, so to speak. We tried to get justice without fulfilling all of their seemingly trivial forms and points and checkboxes and all those things. But we are here now, and we are changing our strategy to go legal. That's why this is called #GoToCourtLegal, because we're going to use the system as it is to get you justice. And so thanks again for being here. This is going to be an introduction to our new course, and we're going to tell you all about it. It's going to be led by Zeke Lehman, so you're going to get to know him very well as well. We'll have a chance for all of your questions and answers, because our commitment in this introduction, in this time together, is to give you everything you need to decide whether you want to join us in these next couple months in this journey to sue your former employer for firing you for not taking that vaccine, or for not giving up your personal medical information. So thanks again for being here. I'm so excited to introduce to you Zeke Lehman. We just met a couple of months ago. He showed up to our research group. I don't know if some of you have seen, we're getting a research group off the ground as well. This course itself will be a small research group as well, but I just wanted to let you know that meeting Zeke was something I consider like a miracle, in the sense that I was looking for someone who, if you weren't a lawyer, but someone who has as much experience and understanding as a lawyer, but who comes from the same understanding of the common law and the importance of we the people as free people. He understands completely the order of authority in common law, but as you'll hear in his story, there's a time in life to get practical and not be puritanical about your approach. So thanks for being here, Zeke, to get to know folks.
Oh, thank you. I'd like to thank everyone here for attending. And I especially like to thank Clint for partnering up with me to provide these clinics. In the short time that I've known him, I believe that we have created a strong bond that will be of great benefit to all of us, me and him included. So let me tell you a little about me. I was born and raised on a Navy base in the Mojave Desert, and I lived there till 1974. That was through high school. I've lived in California all my life. I have 3 sisters and 1 brother. My dad's a design engineer, and my mom's a substitute teacher, an English major, and she volunteered for the Democratic Party. I tagged along as we campaigned for Kennedy and Johnson. In 1976, my brother introduced me to an active member of the Libertarian Party, and that sparked my interest in liberty and freedom. I became a state delegate, state and federal delegate. I received a $1,000 scholarship from the Libertarian Party to attend Chico State for political science. In 1982, that was a year after I had my year in school, I spent 6 months enjoying my own personal freedom and liberty, hitchhiking across Australia. Loved it. Within 10 minutes of being picked up from the airport by my parents, when returning, my mother says that the taxes are destroying our small classified ads paper business in Grass Valley. My reaction, without thinking, must have came from my libertarian background. Well, join a tax revolt group. She did. And that was the beginning of what became our family law firm and our stand for liberty, justice, and the American way. We turned in our driver's licenses, and my mom received a $250,000 tax assessment from the IRS. Even though she and all of us were totally devastated, we remained extremely positive. We were buried in legal work, teaching what we learned while defending tickets and fighting the IRS. We faced more tickets and attacks from the law enforcement, but kept going because we knew we were right. We stood on the Constitution and the liberty principles. It got so bad that I left Grass Valley. I went back to Chico. I changed my name to Zeke Lehman and began to study in the Chico State Law Library 4 to 6 hours a day. So when I'm buried in these books, I begin to realize that we've been banging our heads against the wall on principle. But I could see a way out by using the due process to get our principles heard. So use the system to our advantage and play both sides. So I began to implement these new strategies, started getting results. This gave me enough confidence to start a legal clinic called the Equity Center, and I opened an office in downtown Chico. I continued researching, helping people in cases from tickets to felonies, mortgages, unlawful detainers, family law, contract law, and various other areas. I've helped over 1,000 people with legal advice and hundreds of specific cases. After closing the office in 2016, I continued to counsel and consult with people that would contact me from my website, powerpolitics.com. In 2020, I was invited to join a legal mastermind group, about 5 to 7 people, and we've been talking and researching the pandemic, vaccines, and the legal cases that are going on presently. From this almost lifelong participation in research and legal experience, I've developed a perspective and an understanding of the law so that I can confidently tell you that I can coach, advise, and help you to succeed in your wrongful termination case or any case related to employment or the vaccine mandates. One of the many biggest takeaways from my 40 years of legal experience, which happens to be what Clint had just told you, is if you don't give up, anything can happen. So I want to give you a little short example that just happened this week. Okay, one of the members of our mastermind class had been suing a tow company for more than 2 years. So last week we're discussing and helping him prepare for trial, and we determined his case was pretty weak. But he was going to proceed for the principal and go for it, but and also the learning experience. He wanted to gain experience in court and that he hadn't had. So on last Monday, he put in his trial brief. And on Wednesday, the opposing lawyer replied and said, we'll see you in court. Then on Thursday, the lawyer called him and said the tow company was willing to fill the tires, put a new battery in the car, and return it to him if he would accept that. He called the tow company on Friday, or yesterday, and they settled. So this canceled the trial that was set for Monday. Again, the moral, if you don't give up, anything can happen. So now I want to tell you a little about where I see us going and what to expect on your journey. I can relate to how many of you feel today losing your income unexpectedly can be totally devastating, as we were. But as you obtain your forms, you formulate your complaint, and you file it, you're going to experience emotional feelings, maybe some unsurety, and maybe some resistance, but that's okay. Because I know how to handle all the resistance any clerk, judge, or lawyer can come up with, so you can relax. Forms, electronic filing, email, and the court rules have made your journey through the courts much simpler than ever before. You will successfully get your paperwork filed, clearly answer and respond to all motions and briefs, and be heard by the court. That's what this clinic is that good. You can expect many of the court myths to be exposed and completely disappear when your approach is to use the rules and procedures to your advantage. The court has been set up for this purpose. This will clear your mind so you can focus on the facts of your case. Our wrongful determination complaint is comprehensive and put together in a logical step-by-step format. This allows us more time to research and focus on the issues. So I can tell you with confidence that after every class with us, you're going to feel empowered, excited, and relieved as you head towards your personal victory for the wrongful termination that you've suffered. So now I'm going to send it back over to Clint for more details on signing up for the clinic.
All right, thank you. Thank you so much, Zeke. Yeah, it's so wonderful to know you because you just have this ability to take all the considerations from just the intuitive sense that something's wrong, and we know it in our hearts. As Americans, we're free. This shouldn't be happening. At the same time, all of the legal stuff where, you know, people want to they want to include things that aren't necessary to include, for example, and you have a way of just focusing and streamlining and helping us keep it simple, because that's one overall thing I've learned from you already, that to be successful, you want to really streamline it. You want to keep it super simple. And in fact, it's the opposition that's going to try to complicate things because they know that's how to win. So yeah, I want to tell you, well, actually, let's open up for some questions right now. Before I tell you about the course, I'm really excited to tell you about what we designed and why we think it's the perfect thing for you right now, given the times. But if you've been with us for a while, you recognize this is definitely a course change. You know, the hashtag go to court first course original was all common law, pure common law. And this one is now legal. We're going the legal route. So if you have any questions, just raise your hand. Hi, Monique.
Hi, thank you. So a quick question regarding a group of people. If it all happened to the group, can they do it together? And if so, I'm sure this has happened to some. You're not actually terminated. They just keep you on, stringing you along with no pay until whenever that would end. In other words, they gave you a reasonable accommodation, Now they're not doing it anymore for whatever reason, so you're not getting any income. Can you do a case like that with a group of people? Thank you.
Well, thank you for that question, and that's interesting. When the group, basically each individual generally should take their own case, and they can all do the same thing, but individually. Now, if they've given you an accommodation, then the question we would ask is, why are they not following the agreement that they made with you? You're always supposed to be paid when you work. So that right there is a breach of the agreement, a general agreement. You're working from where you're not. And then, yes, you can go forward with that. I don't usually suggest we do class action, which is what you're talking about. That's what a lot of lawyers do that. But I found that usually each individual could prepare the same paperwork and have the same issue and bring that up to their employers, because that is a breach. If you're working and not being paid, that would be the same for anybody that goes to work and is not getting paid.
Is that a mass tort?
It's a tort. Well, actually, I don't think it's a tort. It's a breach of contract in this situation. But to go and do a mass, that is it probably can be done. I've never done a class action suit. That's what lawyers do. And when you get into a class action suit, then you're putting all those individuals in the same class. And I like to keep it individual. Hey, this person went to work, didn't get paid. And so did that one. And so did that one. So from a lawyer's perspective, he might want to group everybody up, get a bunch of money from everybody, and then present it as a class. But this is, I've come to the conclusion where we're all individuals. And, you might not be getting paid, you think, because they have said that they're accommodating you. If they're accommodating you, you should be getting paid. Why are they not paying you? They might be not be paying you because you're a woman. The other guys that aren't getting paid, they may not be paying them because they have some other prejudice against them. So to find out the prejudice against you, it could be the same from an employer or not. But I would go individually and with the same issue.
Individually. Yeah, so I hear a couple things going on. So many, it's great that you're thinking of others, and we do encourage people to work together. The reason we're doing the course the way we're doing it is because we recognize that there is enough similarity amongst you all to allow us to leverage, a group setting, a group course. But at the same time, we're well aware that every person's an individual, and the facts of your case are unique. And even within your own company, other people in your own company, the facts that might be different. And what we're doing here is we're not creating a one size fit all, but we are focusing on a civil suit in which you sue your employer for breach of contract by having treated you prejudicially, as the law prohibits. The state law, federal law prohibits in employment and other areas, housing, etc., to discriminate against you for if you're in any number of listed classes, for example, race, creed, gender, age, medical condition. Depending on your jurisdiction, it's quite a list. And in fact, that's what we're going to be doing in the clinics, is we're going to have you look into your state's laws to see specifically what's named, because that's what you'll end up putting in your complaint. We are working with groups of people, and yet we aren't losing sight of the individuality of each and every case. And indeed, you will be the one to determine what your complaint will include. You'll be the one. We'll give you all the information you need, various options, pros and cons, and yet you'll be the one to say what you're going to stand on. So get those folks to join up.
Some of them are here.
Oh, great. Welcome. Welcome to you all in Los Angeles, right?
Right, right.
That's
Just
right.
really quickly, we were told by one attorney that the mass tort is not a class action, so was just wondering about that, since you said that.
Right. So there's different things called, there's a class action suit and then there's mass action, which is more of a like a political campaign where you get everyone to get on the same page. But yeah, we can talk about that in the course for sure, in terms of a broader strategy for more than one person. And I do see the advantages because again, a lot of what's going to take place here in terms of winning is psychological. And when they see a great number of people coming, that could be to your advantage. It might be to your disadvantage too, because then they start looking at the payout and they say, "Oh no, we're gonna have to. It's going to be worth it to us to fight it versus payout." But in the course we'll run through all of those pros and cons with you.
Good
All right,
question.
thank you.
Yeah, I want to get to the next question. So I think we've said it now a couple times, but we're doing a civil suit against your employer for breach of contract based on discrimination. And you can choose that. For a lot of you, that it's going to be religious or creed. Some of you might have a medical situation. We definitely want to talk about if you have had COVID and you had proof that you recovered and you had natural immunity, are they being prejudiced against you for your natural immunity? That could be an angle. So Noah, go ahead with your question.
But I want to add on to what you stated about the discrimination, but I want to read, I have a couple questions and then I want to read what my my document says. If I signed my release waiver back when they terminated me, they put down in the document that this release and waiver includes, but is not limited to, any claims for wrongful termination, defamation, or any other common law claims. Any claims for the breach or any implied written or oral contract, excluding any contract claim resulting from a breach of this agreement by said company. And it says any claims of discrimination, harassment, or retaliation based on such things as age, national origin, race, religion, or blah, 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 handicap, medical condition, or any other form of legal prohibited conduct, discrimination, or retaliation. I reacted to the email that they sent out saying that the government is now a customer of the company, and the customer is now demanding that we all take the jab or submit to the paperwork of medical exemption, which we don't get in California, and then the religious exemption, which I was already telling them, no, I'm not going to comply with any of it. And then when they sent out their email, I told them, no, why would I continue to show up for a job that doesn't want me here in a couple months and telling me that I have to go find a new job in April? And so they said, well, can we talk about it? And I said, sure. And so they called me up and they put me on mental health leave for a week. And then in the week that I was actually out, they put on a pause on their mandate because the government changed. And so how can a company, a customer of a company, tell the employees of the said company what to do? That's like me walking into McDonald's and telling everybody they have to wear a diaper, right? Or if I have the injection in my arm, sorry, there's a long story to this, but they put in my document that we can't sue for wrongful termination and all that stuff. But clearly,
did you sign it?
Hell no. And I never returned their equipment either, too.
Okay, got you. Wow. And everyone's got their story, and that's wonderful. We're gonna learn your stories in the course, because again, we're working toward a general recipe for you all in terms of the wrongful termination based on discrimination, and that is a breach of contract, and that is a civil suit. You do have a right to be in court. We guarantee that if you keep at it and you want to, you can get all the way to trial. But our overall attitude is that you're going to get settlement with your employer one way or another before you ever make it to trial. That is actually what happens most of the time in civil lawsuits in this country, is that they don't ever make it to trial. I guess it's a modern myth because of TV and such that the trial, that courtroom was where it all happens, and yet that's not really the case, is it, Zeke? The trial is all the merits of the trial, all the facts of the trial are all documented and shared amongst both parties well before the trial, and they're going to be making calculations. And you're going to be making calculations, and they're going to be deciding, is it better just to settle with this person?
Yes, and I would like to just add to answer his question. We would investigate the retaliatory action that they took against you. That would be part of the discrimination against you because they retaliated against you because of what you did. And we would define what exactly you did. And then we would look at how they retaliated against you, because that hearing, they said, do you want to talk about it? What happened in that hearing, we would analyze and look at that hearing as if it was a fair hearing, due process, and show that they didn't give you a hearing, they retaliated against you just for what you said.
Yeah, that it's almost like that document that they wanted you to sign is a list of all the things that you can consider using against them. They just gave you it all. But we'll help you focus and pick one or maybe two. Again, we want to keep it as streamlined as possible for your success. All right, Hadassah. Did I say that right? Welcome.
Yes, perfect. Thank you. I may have to make a private one-on-one appointment with you, but what's going on with me? I work for the community college district and I'm in an administrative process with them. I gave them a notice of lien and they sent me I did it registered mail, but they're responding to me now via email saying, we're offering your job back and you can't do what you're doing. You have to put it in the proper courts, and you cannot file a commercial lien against a public entity. And you have to file damages with the appropriate court and then serve the district. So I'm like, okay, do I go into this meeting? Do I not? I just logged into that email account because I haven't been all semester because I've been off since February. So now I'm like, what do I do? And then this meeting came along, so I figured I would join. But I feel like I might need some one-on-one counsel. So thank you.
Yeah, that's definitely going to be a possibility for sure. But you reminded me of something I've been wanting to say. It's a very simple way of putting it. After all that you've done so far, whether you were with us for the first original hashtag go to court and using the common law approach, or maybe you've done some action with your regulatory agency in California, it's called the Equal Employment Opportunity Commission. You know, maybe you've done some things already, but what your employer is telling you, not necessarily in words, but that was what you just told me, Hadassah, was close to what they're really communicating, and that is, okay, go ahead, sue me. That's in fact what they're saying. And so your employer almost said it for you. Okay, Hadassah, then what? Well, just sue me then. And so that's what we're going to do. We're going to take them up on that. Do you have anything to add, Zeke?
No, that was good.
Okay, good. So Leslie, we'll go with your question.
Yeah, awesome. Appreciate. I'm just grateful, Clinton Zink, for you guys doing this, and it's great being on communication with fellow warriors. I was offered a job. We decided that I wouldn't be an employee, but I would be a contractor. But basically, I'd be working there full time as a contractor. And then when I refused the job, they retracted it. So I actually never started the job, but I was offered the job as a contractor, and then they retracted the offer because I refused the job. So I'm just wondering what kind of potential case I may have against that situation.
In my research, I did see that, and I do believe that because they made an offer, and even if you didn't get hired, that you can still take action. We would have to go and take it and really reduce down your situation. Yes.
Okay. Awesome. Great. Thank you.
Yeah. So that's an example of some variation. You know, we're focused primarily, the conversation will be a lot about if the termination, you know, that you were terminated wrongfully. But if they also didn't hire you because of prejudice, that's also a claim. It's also a complaint. You can press them on that. All right, we're going to ask Philip to offer his question. There you go.
Okay, very good. Anyways, I've been fighting this since August, and for a religious exemption, my employer said they would comply with that, but their religious exemption was not reasonable. They wanted to work me on weekends alone, which a water plant operator works weekends alone anyways. Then on Monday and Friday, because we were 2/12s on Saturday and Sunday, then Monday and Friday, I would have to work 8 hours either away from everybody or take time off without pay. I wasn't going to accept that. So I filed a case against my employer for discrimination. And that went with the EEOC. And then so that was back in December. Then my employer responded in April with over 232 pages. They hired a lawyer with all the CDC, OSHA stuff, which, as you know, they do not make law, and has to go through the legislative body and give them a code of law. So it's a bunch of hogwash. So I decided to amend my charge from a religious exemption to Title I under the Americans with Disabilities Act, because I found an ADA advocate through the Zunga.com. This guy knows legalities. Wow, he's tremendous. So he does the paperwork for me for only a couple $100 a month. I thought, wow, that's great. This guy knows what he's doing. He's fought this before. The best advice he gives is you don't want to do class action, just for the simple fact that if you do that, it's money, millions of dollars of money for lawyers. They love class action. He was part of a class action with 40 people. When it was over and done with, and the lawyers won, he got a check in the mail for $5. So anyways, I'm going through that now. I've asked the EEOC to give me the right to sue. That was over a month ago. They're taking their sweet times because, I don't know if you guys know this or not, but the EEOC is helping employers fight this. They're really not on your side like you think they are. That's why you got to get a right to sue and go around them. My employer decided to go around their own lawyer because I was told, don't tell them where you go on vacation, because they want to know if I go out of California, I got to be quarantined for 10 days when I get back. 2 unvaccinated people are not allowed the same vehicle together. I need to give them my vital signs every day. Again.
Sorry.
Yeah.
This is fascinating.
Yeah, it is.
I just wanted to know if there was a question in terms of your consideration.
Okay. So anyways, I was just wondering, how long should I wait for the EEOC to respond and get my right to sue? Because they have not done so. So I don't know if they just take their sweet time.
A great question. Yeah. But that's definitely part of the course. We've anticipated this already. And I'll tell you more about exhausting your administrative remedies first. We're going to definitely, that's included in the full package here. But yeah, I'm glad to hear, well, not glad to hear that they're dragging their feet. It's just confirmation what I've heard from many others, that they're dragging their feet. And there are alternatives. You probably noticed you can go straight to right to sue without having them do the investigation, which is what's taking all the time, right?
Yeah.
There's the investigation.
Yeah, the fascinating thing real quick is I refuse to give my temperature anymore because it's against my Fourth Amendment rights to privacy, and they terminated me for that. Okay. And it's interesting because I have keys to a multi-million-dollar water treatment plant, but they can't trust me to say, hey, I don't have a fever. That's all you need to know. And yes. I got fired.
It is ironic. It is definitely, it's contradictory, it's ironic, it's maddening, all those things. And your story is like everyone else's.
Yes.
So, so do you want to add anything, Zeke, about the administrative procedures by these regulatory agencies?
Well, again, in his particular case, retaliatory action, yes, there is the process when you, and they take a long time. There is, I believe, we'll look up the time frames that they're supposed to respond with. And then, but they do delay these things. And then it's incumbent on us to say, okay, you passed the time, then we have to take it to a court and ask them to sanction them or even to their administrative agency. However, there is a process called injunction that we can formulate and put into the court to say, hey, court, here's my situation, and I think we're going to win, and it looks like we're going to win. So we want you to now intervene immediately and stop them from doing what they're doing. And the status quo should be, I continue to work until this has been settled. So that is something that we all are may look into, especially in these cases. So that brings up, yes, we would definitely look at all of this stuff. That's what really the clinic's about.
All right, Philip. Yeah, that's an interesting situation you've got there. So hope you stay to the end, because I'm going to tell everybody about the course that we have, and you can decide if that's going to be for you, if that's going to work for you. All right, Brad, your turn.
Yeah, hi. I just question, is there a statute of limitations in which we can sue? I went to the EEOC, and then I think with federally, my statute of limitations for the right to sue ran out with them, because they told me to go to the Georgia state EEOC, in which case I was having a hard time. But anyway, is there a statute of limitations in general just to sue about this?
In general, it's 300 days in the federal. In California, it's 3 years. So we do have to look at your state, each state, and find it and then determine. You know, that it gets more difficult. However, the statute, we look at when the statute of limitations actually happened, you know, because if you did get fired and you're still in a negotiation, and maybe they rehired you as in some of these, you know, there are some ways to get around it, but we have to look at your situation and creatively come up with ways to do it. Statute of limitations are a problem sometimes. And as I was telling Clint, I remember one time, if you don't know what's going to happen and your time is running out, if you just file your complaint, then you may save statute of limitations. So the statute of limitation to file is federal, state differently, but there are sometimes ways to get around it, depending on the situation.
Very good. Very good. Yes, that's a good question, Brad. Everyone needs to pay attention to their statute of limitations and get the complaint in before it runs out. So you don't have to be creative and just stop the clock. Oh, Becky, great.
Hi. It's been a while since I've talked with you. So, you know, I worked for our school district for 19 years. I refused to get the vaccine and ultimately was placed on paid administrative leave. And then that switched over to unpaid administrative leave. I did attend a Skelly meeting, and my feedback in that meeting was a 20-page letter that I read. So I guess I'm wondering if I'm able to move forward with this, because ultimately I was fired. And so I did, on the grounds of not only did I not get the vaccine, but I also refused to test weekly. So because I refused to take the test every week, do I still have grounds to move forward, or am I truly insubordinate?
Great. You really put it to the point. Absolutely. And I just want to say to everybody too, because you mentioned you got fired. It's not great to get fired in most cases. Most people, some people are kind of relieved after all. I've heard a lot of feedback that they're kind of glad they're moving on.
Yeah.
They're moving on in a way, but being fired is a very clear violation. You know, you can't. It's not nebulous, and so it'll definitely figure into your complaint. But Zeke, what do you say about? I guess you're asking Becky specifically about mask wearing as opposed to vaccines. If that's a prejudice, still a claim for prejudice.
Well, I mean, the mask and everything, and that was always part of the paperwork, the common law paperwork that was sent in to them. But you know, they were saying all you have to do is you can go to the drugstore and pick up a COVID test and just send us a picture of it. You don't. I mean, they were trying to make it as well. Really, they were putting you in a position where you could be dishonest. And yes. I put my foot down and said, absolutely not. I will not do that. And also, by accepting that option, that would put me into a database of testing. And I don't want my name in a database.
For sure. You had every reason to, and thank you for standing on principle. It reminds me, there's probably a good percentage of Americans who are cheating, and they just can they justify it, and that's what they've chosen to do to fake the vaccine proof, or who knows, all those kinds of things. The people who tend to come around our courses are very principled people and are not interested in finding some sort of cheat.
Right.
We want justice, and we want to be true and honest. So I appreciate that very much, Becky.
Of course.
So I would, my initial response, I would take the perspective, and my first question would be, were you required to put in a test of some kind weekly in the first 19 years of your job, say, or the first part of your job? Okay, so that would be a point that I would look to see how they're being prejudiced now.
Right. And I pointed that out in my 20-page rebuttal to them. And, ironically, I was the office manager at our school, and I had to leave my back office for 2 hours each Friday so that they could use it as a test location.
Yes, once again, it's just insult upon injury. It's so much irony and contradiction, and it's just everyone has a story. I tell you, that is just it just exemplifies the horrors that we're dealing with. So, Becky, I hope you consider joining us. It sounds like a perfect match for you.
Yeah, I think I will.
Okay, cool. All right, then let's see what Sean has for us. Sean Donovan.
Yes, hi. I'm very similar to Becky and the other gentleman that spoke before her at the water treatment plant. I was a New York City DEP employee, union member. AFSCME is the national. DC 37 is the city union. I refused to comply to a mayoral mandate and was removed from the property and brought up on a disciplinary charge with a 30-day suspension. After 30 days, within those 30 days, I had a hearing because there's a legal process to terminate a civil servant, and so the first step is what they call an informal hearing, where I established that there was no FDA approved drug available, that mandates aren't laws and things of that magnitude. However, that they're not supposed to be able to put you out 30 days and then another 30 days. However, they did. And so there was charges brought up by the union saying that they were not allowed to do that. What they did was they allowed the process to filter through. And then what happened was, after several months where I was supposed to get an actual scheduled hearing, the city dropped the insubordinate charges and lumped me in with the group that refused to take the jab, stating that no longer were they going to pursue the insubordination, but now as I was informed by the lawyer that was appointed to me by the union, that now my situation has become where it was similar to a licensure requirement, that I needed to provide proof of jab the same as I would need to provide like a TLC license or whatever licensure to perform the job. And because I didn't have that, I no longer qualified. And since subsequent to that, I've been terminated. So my question that I'm getting to is this. When I raised that issue to my lawyer that was appointed by the union, I said to him, this doesn't sound legitimate to me, that I was in a legal process for a due process hearing, and that's been dropped because the employer chose not to pursue it and lumped me into a mass termination. And I feel that there was a conflict of interest of some sort there. At that time, the lawyer that was provided to me by the union said, "You're correct. I have a conflict of interest and I can no longer be your lawyer." And a week later, I was terminated, which God works the way God works, thank God. And subsequent to that, I have put on a notice of filing. There's for wrongful termination. Then there was a dismissal on portions of the mandates in New York City, where they've allowed people to go back to work in private sector. So now I want to also file for discriminatory, and I also want to file a lawsuit against the union, both AFSCME and DC 37. I want to sue the shit out of all of them. Excuse my language, but that I want to
Good.
sue them all, sue everybody.
Yeah, good. You're going to learn. We're going to take you through one lawsuit at least here, and you can apply it to multiple people if you want. We're going to be focused on this mostly on the prejudice in firing, in having fired you. But yeah, you sound like the fighter that we want. That's who you're going to be when you join us in this course. You're going to be with people who are like you, who do not give up. We're not sitting taking this. We're not just going to put up with it. We're not going to go move on with our lives. We're not going to lick our wounds and go away. We're going to fight and bring justice forward in your life in real time. Now, the question to you, Sean, is: do you want your job back, or do you want financial compensation?
I want money. I want it, and that's the big question that I'm really getting to: is the sequence of whom I bring it to court important, and because in my mind, if I go after the union, I can take their legal funds, and then I can take their legal funds and go after the city.
Wow, that's a great question. That's a perfect question for the course. So everyone is, as you've heard from their various questions, everyone has slightly different situations, and that's why we created the course the way we did. I'm going to tell you about the details of it so that you can decide for yourself if it's going to be for you. But we're working with trying to look for a uniformity, a similarity, so to make it possible for us to do the work together, and thereby save money, all of us. But at the same time, we also created ample space in the course for everyone to have their specific details addressed. And so, Sean, everything you've said is, as far as I can tell, even with the administrative hearing you went through and all the details with the union, I still believe that you're just like the rest of us. And Zeke, can you confirm that ultimately, when it comes down, boil it down, distill it down, he's right. He's right in the money with us. He's right in the pocket with us.
Yes, exactly. And the first with his union and what he did when he went, and then he won. He won in that partial of it, and then they switched it over, and his lawyer explained to him it's a licensing type thing, but actually, as he's correct, it's a discrimination. So we have to bring that to the point exactly, right on. Exactly, you understand.
Bingo. Okay, good. Thanks so much, Sean. Yeah, you guys, this course, I'm eager to tell you all about it, but I'll tell you right up front that we're creating it in such a way that we're intending for you to get your justice before walking into a courtroom, into that trial that you see on TV where everything seems to happen. In reality, in truth, and Zeke has been helpful in getting me to stop thinking about the trial as the ultimate, because you see, in the way it really works is that both parties, you and your employer's lawyers, will have all the facts and will have all the questions of law on paper in front of you, and you'll be looking at the same exact issue. And that in itself is the case, if you will, before trial. And so there's going to be a number of actually, there's going to be some surprises in the sense that things that they will bring forth that you might not have anticipated, but actually Zeke knows about a lot of them, and he can help you prepare for those things. But at the same time, you're going to get some good news surprises in the sense that you don't know that these companies often make mistakes in their execution of their policy. They try their darndest to fulfill all of the regulations so they don't run foul of the legislation that regulates them. And yet they mess up, whether it's due to non-uniform application of the policy, or they didn't do one step that they missed. And their lawyers will know it eventually. And they will start to wonder if we know it and if we're going to make that a point in the case. And will they, and when they see it all, and it'll become clear, they'll see the writing on the wall. They're going to advise their client, your employer, it'd be better to just settle. Okay. And so I guess I might as well say too, because I know it's a question out there that you have, what about this financial settlement? What are my damages? How do I quantify my damages? And again, the good news is that doesn't have to be dealt with in detail until after the trial. Once you've won your suit, then that's when the actual dollar amount will be determined. But for just so you know, from the get-go, the complaint itself will say $1 million, $2 million, something, which is not unreasonable, especially considering inflation, right? Like $1 million just ain't what it used to be. But so you're going to put lot of zeros out there, and then once you win, then there'll be a separate conversation between you and the lawyer and the judge about what the actual judgment will be. So I hope that preemptively answers some questions out there. Sounds like I'd love to have you with us, Sean. I want you to I want that fighting energy. I know everyone's here, but a New Yorker with that with that kind of grit. Oh, I'd love to have you. All right, Nelda.
Hi, Clinton. Thanks for having this course. I really appreciate you having this this Zoom call as well. And so I hope, Zeke, that you can tell me that I'm in Maryland. I hope you can tell me that our statute of limitations is longer than the 300 days of the federal, because I was fired a year ago for not wearing the mask. I've been fighting unemployment at this point, trying to get my unemployment benefits. And that at this point is now going to the circuit court. We've proven that there was no gross misconduct, which is what qualifies you for unemployment benefits, but they still use illegal processes and still deny my benefits. So that's going to circuit court as an appeal. And in the meantime, I've been talking to my lawyer about suing the employer also, because it was, he agrees that it was a wrongful termination. But like I said, I'm hoping the statute of limitations hasn't run out for my state. And I guess that's my big question is that. And then also, will we be filing, if we go through this course, are we filing as pro se or as a private individual? I guess that's my main question.
Well, we're doing it pro se without an attorney, and you can find that out. And when in the course, I'll show you how you find that out for your state. Each state has the separate statute of limitations. I'm in California. I've lived here all my life, so most of my research has been done with California law. But we can find out any state. You can find that out. I'll show you how in the first class of the course.
Okay. All right. Yeah. Good. Thank you.
You're welcome. Yeah. So we're going to move quickly. So you're going to have the chance to move as quickly as you want. There's some things that, we have to wait for the others to respond, but we're going to accommodate those of you who want to move fast, or maybe have already done some of the steps already and need to move on to the next step. So we're going to accommodate everybody, and we recognize there'll be some people who will be way ahead of the race, and other people will be toward the end of the race. But we'll work with all of you. And that statute of limitations, we need to figure out not only the actual timeline, but what stops the clock, and filing the complaint typically will stop the clock. So we'll get to that as quickly as we can in the course. Let's go to Helen.
Let me get my video on here. Hi.
Hello, welcome.
Thank you. My name's Elaine, and I live in Colorado. I was working as the experiences director for assisted living and memory care. I was actually laid off from our hospital when they laid off a bunch of people, like 100 people, right after the pandemic started. So I had that layoff in 2020. I'm a recreation therapist. And then in 2021, so this fall, when Colorado mandated the vaccines, I think we were early in that mandate. I was given notice that I would either have to get vaccinated or be put on unpaid leave. And that when the pandemic subsided, I could come back if it was safe for the community. Since then, well, let me back up too. I was working with the elder community, right? So supposedly that community is, they don't want to risk anything, right? Because that's the most vulnerable community. So regardless, through the whole dark winter of the pandemic and everything, I brought a ton of life and energy into the community. I was even serving up champagne from a cart wearing full PPE, like head to toe, did everything. I tested twice a day, sometimes 3 times a day if they asked me to. And also every week we had to send out tests for all the staff 2 times a week. And then the vaccine comes in, right? And then all of a sudden I become the dirty person, and I'm not fit for that community anymore because I wouldn't take it. And they had COVID in the community too last fall, with everyone being vaccinated in the community. So
yes.
So it's, and the place that I worked at was like right down the street from me. So I passed by it every day, multiple times a day. So there's a little bit of that going on for me where that's tough.
Yes.
I did file with the EEOC. I it's under investigation now. They did a rebuttal from a lawyer, and I did I just wrote a letter saying all the inconsistencies, because now that the pandemic has subsided, they still aren't having me back. Even with the CEO, I talked with him and asked him for compensation, and nothing. Like, sorry, this is hard for you to hear, but we've got nothing for you. And
we'll see what they say once you get your complaint. So let's get to the question.
Yeah. So since it is healthcare and elder care, is this still something that I can do?
Yeah. Does that make any difference that the line of work you're in?
It doesn't. No.
Well, let's see what Zeke says.
Well, she said supposedly the elder are more susceptible. Well, that's what they're presuming. That's what they're saying. When we write our letters to or go through the process, there is a whole other process called discovery. And so we want to know if that's true. Is that true that the elderly are more susceptible? All these things that they're alleging, we want them to put it in writing and say it's true, because we're finding out now that it isn't true.
Right.
However, I want to say that they just came out with a court case, the Supreme Court, that overturned Roe versus Wade. And this case was made 50 years ago. And people, it was a wrong decision, and they overturned it. It took 50 years. But this is why I say, when we focus on what our issues are and we attack, then there's a process. I said, we can go to the court. We can ask the court to immediately give you back your status that you were in before the pandemic. And then we can talk about from that point on through the pandemic to find out the truth of this matter. Because we need those facts. They're acting on those presumptions. So the way in which they fired you and the reasons they used there's a lot of holes in those.
Yeah,
and
those are the facts of your case. Those are the facts of your case, Helen. And we're gonna go through the facts of everyone's case. We're gonna have you write them down, chronicle. We're gonna workshop it with you, with everyone here, so you can chronicle all of the facts of your case. We're gonna research all the legislation that's relevant, and we're gonna create your allegations. And Zeke just used the word attack. Okay, so guess what? You're going on the attack, and they're going to have to defend all of those rationales they used, because they won't. And look, they don't hold water. Let's just be honest. Between everyone here knows that any justifications people use, it's crap. It sounds good, it works, But they, in the end, they're going to have to prove it, and they know it. They're going to learn very quickly that they're now going to have, they can't just say stuff and expect people to accept it. They're going to have to officially and formally do it under oath, on record. And once they start feeling the heat, they might change their tune. They're suddenly going to have something for you, Helen.
Well, yeah. I'm not sure I want to go back there.
Well, yeah, that'll be also a question that we'll address. It's one of the first things what we're going to deal with. What does winning mean to you? So
And
I hope
then
you.
I have one more question about just how does it taint my image in my community because we live in a small city, maybe 10,000 people, and there aren't a lot of career jobs. So when you sue a company, that's public record, right? Like, is that going to affect my ability to be hired by another big business?
It's going to be, it is public record, as a matter of fact.
But they can't retaliate against you for doing that.
Other employers.
Right. No one can.
Okay.
But at the same time, look, everyone here is we're fighters here. We're courageous fighters. I'm directed by my higher power. Everyone, just so you know, if I haven't fully introduced myself, I think some of you know me better than others, having worked with me and others in previous courses. I am directed by God, and I'm fearless because I know that I will be provided for. And as long as I do God's will that He has directed me to do, I know everything will work out. I put myself out there. I take the risk. People will do what they're going to do. And that is secondary for me. I just do what's right. And I sleep very well at night. Spencer, go ahead.
Hello. I'm in a position where my company is moving back to the office, and they ordered us to submit our medical records, announce if we were vaccinated or not. I refused to do that, and I just didn't answer the form. So HR people finally came around to talk to me, and I said I thought I was remote already. I was hired about 2 months before they started to make the vaccine mandate, basically, and so. Yeah, I think from there, I submitted a remote request with my higher ups, and they made it temporary until like 5 months, like as a personal hardship thing, under the assumption that I was vaccinated. Anyways, the HR people got back to me, and they assumed that I was, one of these no-vax people, so I have a recorded conversation of that exchange, and
back it up. You have a backup of it. I want to make sure you have a duplicate of that.
Right. And anyways, I think the strategy right now that I'm going for, I'm actually trying to go for a medical accommodation, like outside of going down the basically they put you in this box where after August, you have 90 days until something will happen. It's like they're, trying to be very, very vague about, keep their options open. But I'm going to try and get a doctor to sign off on, maybe some respiratory condition or something to claim, try and gain a reasonable accommodation. But I'm very new to this, this legal stuff, and there's a lot of remote jobs out there as well. So I'm still, I'd like to go into the fight and, educate myself and learn, but I, also like just, there's a lot of, other job opportunities. So, but this is very interesting, and it's good to hear all your stories. So thank you.
Well, thank you, Spencer. Thank you very much for being here. We definitely would love to have you in the course. It's going to be flexible enough to include people who are still on the job but are being treated a certain way. There's firing, hiring, and just in the way that they treat you. But we'll see the facts of your case, and that recording will be critical. So again, ask yourself, do you want the job? Do you want to keep that job, or do you want to move on to another opportunity, or do you want financial compensation? So Andrea, how are you?
I'm doing very well, all in all. Thank you very much. My question is, when they finally let me go, I'm a nurse, they said that they could no longer support my position. And they did not say anything particularly about COVID, and they let me go. They had hired some other nurses, and so I knew what it was all about. So I
Okay,
just.
great. So that's a great question, Zeke. So we're going after prejudice in firing, but some of the facts might seem to indicate that they fired for cause or for other reasons, downsizing or different things. What will we be able to do? We can still move forward, right?
Dissected, it sounded like prejudicial, and they're not, and then they're going to not support that another doctor. I mean, I'm not sure exactly how that works between nurses and doctors and what that actually means. But you're right, we have to look at it, what the prejudice is, because generally the statute has provided us with the prejudicial action. And we're looking at it, if we're standing it on principle and the principle of a religious objection or creed, we're really saying we have a firm belief, a sincere belief. And when we say we have a sincere belief, they're trying to knock us off of that point. And when we know how to stay on that point, they have a problem.
That's right. That's right. So Salandria, I think it's worth considering moving forward because again, in the process, they're going to have to prove their claims. Your allegation in one for another is that they fired you because they were prejudiced against you. And even though they might say otherwise, the facts might prove that they actually were prejudiced. And that's going to be the job of everyone here, is to get the facts on record showing that they did in fact treat you according to prejudice. So yeah, that's not going to stop you, Salandria. That's not going to stop you at all.
Okay, great. Thank you.
Mm-hmm. All right. Hi, Kimberly.
Hi, Clint. Nice to see you again.
You too.
I'm curious because when you're talking about we'd be suing them for discrimination.
Mm-hmm.
And that my employer was a church, and I was at the time a member of the church, and that church supported an employment mandate for vaccines.
I told you, Zeke, I told you there'd be some interesting questions, right? So how can you stand on religion when it was your very own church?
Right, and everything, all the other discrimination possibilities, I don't fit. I'm a cis white woman, I am over 40, but I was a singer. I can still sing. So I don't know if the religious thing is going to work. What's your best guess?
Well, I missed that part about the church.
I was a member of the church.
Okay.
And the church made a decision in their vestry to not employ any people that weren't vaccinated. So I don't know, the only possible discrimination grounds that I see are religion, because I don't fit any of the other of them.
Yes, you fit in that.
I do?
Yes.
Yes.
Even though the church of which I was a member decided that they could discriminate against me?
Well, when you go to that church and you open the Bible and you show them where Jesus told us that each one of us is a church. So you're going to go to them, hey, I'm a church. I just came to associate with people in community. If you want to call yourself a church, fine. You can call yourself a grocery store. You can call yourself whatever you want to, but I'm a church and you can't discriminate against me because of my religion.
Which I had joined with theirs though.
No, this is the point. You didn't join with theirs if you're an individual. And this is what the employers and people are doing when they they say, oh, you're a religion, then they'll ask you, what religion are you? Are you Christian? Are you Muslim? Are you this? And as soon as you say you are one of those, then they put you in the category. It's
Fascinating.
an
This is
understanding,
fascinating.
but
The short answer is you can move forward. That just because you're a member of the church doesn't mean that they didn't discriminate against you based on religion and creed. In fact, they did, if you ask me. So this is going to be fascinating. Just imagine their response to your complaint. Well, she was a member of our church. How can she claim it? That's going to be fantastic. It's going to be fantastic. And
Thank
who
you.
knows? Who knows? Some of you, I don't know. Some of these situations are so almost like God, made them in just. It's amazing, right? Here she is, a member of a church, employee of the church, and she's going to sue on religious prejudice. Who knows? Some of the cases that come forth out of this group could end up making some important precedents for our country, but that's not our general interest. We want each and every one of you to individually win however you end up winning. Again, if it's just because they realize they made a clerical error in their firing of you, and it's like, uh-oh, we better just settle now and get out and not have to get to trial and deal with the merits of the case. That's going to be, if that's for you, okay, as if you would consider that a victory, then this is the course for you. So Kim.
Awesome. Yeah, so this is like a totally different use case, and that's why I'm calling in and trying to figure out, if this is something to pursue. My daughter is in high school, and it's a nonprofit organization that onboarded her. She had a legit interview, etc. And then I talked to another, person who was heavily, when I started with the common law approach, and said, you don't really have any losses if she's being onboarded into a summer program. It's not like she's losing a salary or something. So I really don't know about, you pursuing this going forward. But this is an educational nonprofit, and it looks really stellar on her resume. But she got denied because I would not allow her to get this shot. So I don't know if this is, she's 17. So she originally got accepted into the program, and then going through the application process, we uploaded, instead of a proof of the shot, we uploaded a religious exemption, which they straight out denied. When we asked if we could submit an exemption, they would not even allow that. And so they're also accountable, to.
Question I think comes down to, Zeke, tell me if I'm wrong, is whether the legislation protects people beyond just employment, but also in schooling and internships, right, and various other
opportunities.
Yeah.
Yes. No one can be denied life, liberty, or the pursuit of happiness without due process.
Okay, so this is then something that we can pursue on a civil level. I've put in I went through the Department of Justice. They sent a letter back saying, go through the Fair Employment and Housing. God knows why. This is not our bag or whatever. I don't really understand. And so I'm just like done with all that.
It's time to sue them. And the question is, how much do you want to be compensated? Yes,
well,
they've done you wrong. Okay. And just so everyone understands, Common or Law Group we would love this republic, this country, to return to a common law form of government where the Constitution is respected all the time, every time. The government is put in its proper role as a servant to the people, and everyone knows that, and everyone acts like that. We're a bit far from that today. But in the civil suit that you're going to prosecute against this entity, you have all the opportunity of expression of your natural rights, just as Zeke was saying. The right to life, liberty, and the pursuit of happiness has not gone anywhere. It's just that this avenue, the civil suit, gets us access to the courts where you will get to be heard.
Exactly.
Yeah, I think they're snowballing me now, and they're just trying to pass the buck, and all these organizations really don't have any of our backs. So we just need to
by suing them, you force the point.
Right.
Yes, they have to respond within a certain number of days or they're in default. Okay?
Yeah, thank you.
Yeah, I'm excited personally because we hit our head against the wall for so many months this last year. And Zeke, he tells, if you remember his story from the beginning, in his early years, he and his family hit their heads against the wall. And finally, he realized, let's just play by the rules. We have a metaphor, right? It's like a basketball gymnasium. You know, we want to play basketball and we're knocking on the door and they're not letting us in to their nice fancy basketball. So we're out on, we're out on the, the dingy courts out on the public park trying to play basketball. And so what this does is allows us entry into the basketball gym, and then you get to play. And we're going to teach you how to play, right? Fortunately, it's pretty straightforward in terms of the steps, as Zeke alluded to in his presentation, that we're living in a time when the court systems have automated things so much in order to help process people faster and deal with the huge number of cases coming to them, that they've tried to automate things and create forms and structures to streamline things as much as possible. So once you do go in to work within the system, you're going to find it's easier than you imagined. I'm going to go ahead and discuss the structure and the pricing and everything for the courses. It's called Go to Court Legal because we're going the legal route. We're going to play by their rules. But in so doing, we get the opportunity to express all the beautiful things that make our country the land of the free. We're keeping in mind the full picture, how you can win without a lawyer by following the court rules through 3 phases. Okay, so we've analyzed the whole situation and we've boiled it down to 3 phases. The first phase is how you can win before you even step foot into that trial where there's a judge and the other lawyers and maybe a jury. And then the second phase is to actually win at trial. If you do get to trial, then there's ways to operate in trial, to prepare yourself for the trial, to select the jurors and schedule witnesses and present your exhibits and delivering your statements and your arguments in your favor. And then if that doesn't work, if you still haven't won, we'll set you up to win on appeal. But that's so far down the road. What we determine is, for now, just to deal with what's right in front of you, we're going to focus on the first phase only, okay? There's so much that can happen in this first phase, and many of you will have won already before you ever get to trial. The whole case is designed in the complaint and the response, so you will get a trial date set potentially, but just as we heard from somebody, what was it, the Friday before the Monday the trial was to start, they decided to settle. That's how it might roll for you. It's a game. It's a brinksmanship. It's like basketball. There's no one way to play a game, but things come up and you adapt. So that's why we've created this course. You're going to get general education and coaching for plaintiffs in a wrongful termination civil suit. And of course, people who didn't get hired because of it, you also can participate because it's very much the same principle. That's the education and coaching that you're going to get from day one. Every single class is going to have an element of education. So you learn the various terms, like what is emotion? What are facts? What are causes of action? All the different terminology, and it's not a lot, 10, 12 different concepts, many of which you've heard of before. One of them is discovery. So you can see here that the way this is going to unfold is that discovery will begin right away. You're going to start gathering the facts that you have and get in contact with your employer. If there's some things missing, you're going to start gathering the facts as you move forward after the complaint. Then you actually get official discovery, which means you force them to produce evidence and make admissions. Even if you want to depose them, which means have them in person, you can interview them on record, on camera. That's a possibility too. But the point is, throughout the whole process, you're constantly adding to the record of facts, the actual facts of your case. The first part of phase 1 is to exhaust your administrative remedies. Some people have already begun that phase. You heard already today that people are already in the middle of exhausting their administrative remedies with the regulatory agencies of the state or federal, who are there to make sure that employers don't discriminate against you on any protected classes. We're also going to ask you to try one more time with your employer by requesting a meet and confer with your employer during this, because that's also considered exhausting a remedy that the judge, if you do make it to trial, will look favorably upon. It is an optional request for right to sue from your regulatory agency. Someone actually was talking about how California, the Equal Employment Opportunity Commission, was dragging their feet. And even though the statute declares how many days they have to respond, to do the investigation based on your complaint and do the investigation and respond to you, in some cases it should be done in 30 days. And we're hearing, though, that for some reason they're taking longer. So you have the option of circumventing that, declining their investigation, and simply requesting a quote unquote right to sue. So either you get a right to sue straight out, or you lodge your complaint with this regulatory agency, allow them to go through their investigative process. That also puts facts on the record. In terms of the gamesmanship, it tells your employer that you're serious. Once that's done, however, you will want to quickly file your complaint. While we're waiting for an administrative agency to respond, you have plenty of time to construct and craft your complaint. In fact, specifically the causes of action that are the meat of your complaint. So you're going to devise your strategy of winning. Again, winning is kind of different to everybody. Do you want your job back? Do you want money? Do you need to have the trial, have it be that you were right on the record, or are you willing to take a settlement, even though they won't admit to being wrong, they'll just offer you a settlement? You craft your allegations based on the facts and the law in your jurisdiction. You're going to organize your exhibits. You need to keep through this process. We're going to help you, but you need to be organized. You'll summons the defendant. We'll talk about who the defendant should be. Is it the CEO? Is it the human resources director? Is it your manager? Who will you be summoning? You'll choose also the best court venue for you, whether it's federal or state. Once the complaint is filed, and of course the complaint goes to your employer, then they have a chance to respond. They have an obligation to respond, I should say, and within a certain number of days. And so we're going to teach you how to deal with those responses, whether that's a motion to dismiss, which is going to be their first go-to, predictably. They don't want to go to trial. They're going to try to ask for a dismissal before the trial even begins based on any number of procedural matters. It will definitely include some education on what you can do in anticipation of those. We've already looked to see there's not a lot that they could use as a motion to dismiss. Right? We're not actually expecting much of that, but just in case. And then they do have affirmative defenses, which could be like, well, I have evidence that she isn't actually religious and she isn't actually sincere. So they do have an opportunity to do what's called an affirmative defense, and we'll handle that as well. And then finally, the last part of the first phase, which is to win before trial, is to move for summary judgment. That will be the day when you look, judge, look, everyone's seen all the facts and all the law. It's quite apparent that this was a breach of contract. They definitely were prejudiced against me in their treatment. It's time for you just to go ahead and just make a decision based on all that's sitting here in front of you before we even go to trial. And that would be a great day. So that's the general outline. That's as far out into the future. Beyond that horizon, again, is the trial, or maybe an appeal of that case to a higher court. All that we're definitely keeping track of. Zeke and I are talking about it, but we just wanted to get something out to you to focus on right now, where you could literally win within the next month or two. And that's what this course is all about. So we have a few options for you to choose from. The whole design is to get you the support you need. Again, we're fortunate that so many of the elements of your cases are similar, but we're going to direct you and try to streamline it to keep it focused. At the same time, allowing that there could be some variations that come up as well. See how much is overlap and how much is distinct from one another. So you'll get that education and coaching for 2 months. This series of clinics goes through the end of August. And so what we're going to do is we're going to have 2 hours on Tuesday nights, starting at 4 o'clock Pacific and 7 o'clock Eastern on Tuesdays, every Tuesday between now and the end of August. And we're also going to have Saturdays at this same time, so noon Pacific and 3 Eastern for 2 hours. And then if you want, you also have an option to attend both Tuesdays and Saturdays, in case you believe that you need that extra support. What you can expect to get your lawsuit filed and ready for trial There's plenty of education involved. You're going to learn the basics of civil lawsuits to be successful. As a plaintiff, you're going to get help in navigating all the bureaucratic forms and procedures of the court. That's where Zeke is just, he's got it. He's not deterred at all. I get a little squeamish when I see one too many forms. It starts to make my stomach ill. But Zeke can just help us pile right through them. And then you're going to understand the people you'll meet and how to treat them, because again, this is a game and it's partly psychological. So Zeke has lots of experience and advice for you about how to relate to the judge and the other lawyers and your former employer so that you can get the result that you want. We're going to provide coaching to you, right? So again, you need to determine your legal issues and define what winning means to you. We're going to make sure you don't get stuck, that you stay motivated. You know, there's a lot of fight in us, but sometimes we can get discouraged, and we won't let that happen. When you come to the clinics, you're going to be enlivened, you're going to be excited, you're going to be with other people, and we're going to keep you motivated. And then you need continuous feedback on your strategy and how it's unfolding. Who knows what's going to come up specifically in everybody's situation. The group support is important too. You know, we considered, didn't we, Zeke, just offering you a one-on-one. You know, you could work with people in a one-on-one capacity. We will make Zeke available for one-on-ones in addition to this course if you like, if you need it. But we realize that there's something important about the group support. You hear things in other people's stories that trigger you and help you be creative and how to deal with your opponent. Get inspiration from your fellow participants, and you're going to share documents too. If you care, we'll have a document repository. It'll make it easy for you to share your documents. And there will also be a private discussion group on Telegram that you'll be invited to. Only participants of this course will be in that private discussion group. We have a pricing structure that we think is fair. This week, the course starts Tuesday. Every class is going to be recorded, and you will get access on your private membership area on commonerlaw.com. All of the clinics, both Tuesdays and Saturdays, will be available to everybody to watch. Yeah, we're going to start this coming Tuesday for the Tuesday session. It's going to go all the way through the end of August. We did this because we realized that some people are available on weekdays and some people are not available on weekends, and vice versa. So this is going to be the tuition. Another benefit, once you sign up for the course, you will be able to become an affiliate with the Commoner Law Group, which gives you the benefit of sharing this course with other people. If they sign up, then you can receive a percentage of their tuition. So that can help. If you can enroll 3 people in joining you, then that will pay for your tuition. We want to get started quickly, and we don't want any obstacles. So we're offering, yes, a reduction in the tuition for a couple of days. This is to encourage you to take action, to figure out what you need to figure out, make the decision that you need to make right now, again, because we are always moving quickly at the Commoner Law Group. We're not holding still. So if by Monday you purchase, you will receive a 30% discount off of the regular tuition. But starting Tuesday morning, it's the regular tuition. And I really invite everyone to consider your alternatives. You can hire a lawyer. I've heard people paid $5,000 up front to the lawyer, and then they have to give the lawyer the lion's share of the financial compensation when they're done. So that is an option for you. But I'm here to tell you that lawyers are not any different than any other profession. You know, they're and there's nothing wrong with it. They're self-employed, they're hustling just like everybody else, and they want your money, and they'll have maybe other clients that they're working on, and you may not get the attention you deserve. That's a perfectly valid route to go. What we're supporting you is, it's called self-help, is that you learn to stand up and manage your own legal affairs. The other alternatives to manage your own legal affairs is to, say, take a class where somebody gives you the instructions, written instructions, and some paperwork templates, for example, and then you're left on your own, more or less, to go figure it out. And you don't get the opportunity to get questions and answers in real time when you need them. And you don't get the opportunity to be with a group who's also going through it with you together. So there's lots of different options, and we've crafted this one because we know there's a need out there for people to do it themselves, but not by yourself, is the way to say it. You're doing it for yourself, but with the group. And that's the unique opportunity for you to choose today. So go ahead and sign up today. You can go to our website, commonerlaw.com. And the very first banner there is hashtag go to court legal. And you can click through to register. If you just want to go straight to the registration page quickly, this is the URL. Now we're going to open it up again to questions. What do you say, Susan?
Hey, first I want to say thank you. This is definitely needed. I'm going to get straight to my question. I was unlawfully terminated by a very large transportation company. So I don't know that this would be, I'm with a group of people. It's probably about, I don't know, several hundred of us that were terminated, and some of them that are actually still working. However, I was terminated. This company is very large, and I have seen how they handle situations in court. So I don't know that this would be something that would be good for me personally and the group that I'm with, because I'm one individual. I'm a tiger though. I'm not a wimp. However, I would be going against some very mean and large and no integrity. They have none at all. This company is wicked. And I'm not saying it because I'm not there anymore. I'm saying it when I was there. But would this be beneficial for me and the group that I'm with if we came into this clinic? We're not going to be fighting. They're going to go to court. I'll say this real quick. My husband also works there, and he still works there. He decided to do his thing. He was summoned to court as a witness of something that happened in one of the facilities that he worked in. And they said to him at the end, thank you so much. You saved us billions of dollars. So that's the kind of company this is. They were wrong. They knew they were wrong. All the evidence was pointing at they were wrong, but they did this little switch thing. I can't tell you what they did because my husband can't, he's sworn by, he won't share what happened after, during the process. But they won their case and they were wrong. So if I paid, I don't care if it was $1,000 per day, if it was going to kick these people's butt, yeah, I would find it. However, is this something that could help a person like me or the 800 other people that's out there under this particular company? How can this one person, like, I'm going to get this information for 2 months? Will that be enough for me to fight 5 or 6 attorneys coming in at me?
That's great questions. There's a couple of questions. There's one's about what could it be for your group, and I suppose I should say we're capping the Tuesdays and Saturdays at 35 people per clinic. So if you have a group that you want to bring on board, contact me at info@commonerlaw.com, and we can talk about creating an additional clinic just dedicated to you all. But I'm going to let Zeke tell you about what it means, how many lawyers they have on their side, how many years of experience they have on their side, all of their intimidating factors. They're mean, she says. They're a mean, unscrupulous group of people. Does that make any difference?
Well, usually when someone gets mean, that indicates that they don't really have the facts and they don't believe that they can win the case. When this course, throughout the course, I'm going to be giving you legal terms and you can understand them, because when you have the foundation and you understand the basic process of the law, you can go against the best lawyers. A lot of lawyers, they know certain things, but they don't know a lot of other things. A lot of lawyers just go through the process and don't understand what it means. They're just getting their money, putting it in. Now, a good lawyer, he is creative. He knows the fundamentals, and then he begins to put in his understandings from experience. He has a bunch of cases, so he learns, oh, this is that. And then even sometimes they'll try something and the court will say no. And then they'll take it up and the upper court will say, oh, wait a minute, I think they're right. See, so when you get into the facts and how the facts apply, so you get kind of theory. We're gonna, I focus on the facts and the process. And so when I hear, well, you're gonna gather your facts, but most of the facts I'm trying to hear, the facts are prejudicial. But I'm looking at when they fired you, see, to be fired, there has to be what's called a due process. And due process means that you get a fair hearing. And that's what that's why they call you in and say, hey, we're gonna this and that. Well, we want to look at that, could be considered a hearing. So we have to break down all the elements of that and break down what the facts that they considered when they gave their conclusion. And that's all like a court case. Then we can look at that and go, wait a minute, they didn't complete the due process. And that's what we'll tell the court. Hey, they're prejudiced because they didn't give us the due process, regardless of the facts. If they did, how did they look at those facts and how did they construe them? And did they construe them prejudicially against us or not? So, yeah, it should help.
Yeah, Susan, it's the thing is, you're gonna, as long as your allegations have some merit, that is, they're not completely, off the deep end, and you will have an allegation against your employer and they will have to respond. And they're gonna do what they're gonna do, and then you're gonna do what you're gonna do, and we're gonna walk you through it. Yeah, and can I just ask you, Susan, what would you consider yourself personally, what would you consider a win? What do you want ultimately?
I want to be compensated largely.
Okay.
I'm an older woman, and I was, they didn't hire me knowing that I had a religious belief, but soon after I got there, I mean, I've had supervisors in their crisis moment come talk to me and ask me to pray for them and so forth and so on. So it's not a hidden secret that I am a believer. I was told that I did not have a religious belief, that my belief was secular. I don't know how you could figure that out.
Exactly. So that's what the point of you pressing this case and being the one to initiate an attack on them. Then they'll have to respond, and that's how it's going to get worked out. If that's the nature of the conversation in the paperwork between you and them, that they're going to try to claim some facts. They can't just say it out. They can't just say you're not a believer, you're not sincere, you're not religious. They can't just say that. They have to have facts. And that's going to be very tough for anybody.
Yeah, well, they said I was also infectious and that I was a danger to myself and to others.
Likewise.
However, they had me in a hearing, and they had me in the hearing for about 2.5 hours with doors closed, no fresh air going. And I said to them as I left, if your statement was true, then you've infected your own self, or did you infect me? And since that was
yes, another fact. No, that's a fact. That's more important than any of their allegations. That's
I have
a
a question.
Uh-huh.
Did they immediately put you in quarantine?
They actually called me back. Once they escorted me off the unit because I did not reach the date that they had given the entire company. They escorted me off the unit, had me out for 5 days, called me back in, came back to work in the facility, the same facility. Then they escorted me off again. I was off for about a month or so after that, called me back to come to work, escorted me out again. And then they gave me some discipline hearing, which the union totally screwed me badly.
Okay, excuse me.
Yes.
I asked if they put you in quarantine.
No, they did not.
Okay, so
I guess they did. I guess they did when they escorted me off the unit.
Okay, wait a minute. Excuse me. Sorry. You said that they determined you were a danger to the society or to them. If
Yes.
that is a conclusion that is factual, then they would be required to put you in quarantine.
They did not. Well,
So,
they
so
terminated.
because they did not do that, what they said was not a valid conclusion, so they lied to you. It was an allegation that was not true. that just shows because they didn't do that. Therefore, they can't use that reason.
Well, they used several. They also used, they said that
And
I.
if they
did not
used that
follow-
reason, excuse me,
uh-huh.
if they used those reasons, they were being prejudicial, and that's your case.
Okay.
And that's how we formulate it. We narrow it down because they say all these things, but they're being prejudicial if they're relying on those things.
Okay. Yeah, they used several things, so.
So what do you think, Susan?
It's definitely worth, I'm not afraid of their attorneys. I just want, if I'm gonna, this company, if I'm gonna do something like this, I want to win. And I don't want to win in the sense that, oh, they patted me on the back, said they were wrong and gave me $50. No, I want to win. I
Wanna
want
win.
to.
So you want to go to
let them
trial and you
know.
want the judge to slam down the gavel and
I
say,
do.
huh?
I do. I want them, I want it to be stated, I want to win, that people like me that believe in something greater than themselves have that right to worship, have that right to say, this is what I believe. I'm not telling you to believe it. I'm just saying, this is what I believe. And that should not be taken from me. I am not only an American citizen, but I'm a vet. And to tell me that I can believe this when it's good for you and not believe it when you want to get trillions of dollars from the government, that's not all right for me. That's not okay for me.
That's thank you for saying it like that, because that's the pure spirit with which this course is designed, the people that we want to attract. That's exactly the spirit here. We're not just trying to get away with something or try to, hopefully get something out of other people and feel squeamish or thinking we're not right. We're all of us standing absolutely in the right. The question is, can we use the law as it's written, statutes, to prove a case? And so I'm just bringing back this slide. We're focusing just the next 2 months on phase 1 and your whole case for phase 2 and phase 3. So it sounds like you want to go to trial, right? Which would be in phase 2.
I would not rather go to trial. However, I know the company that I'm dealing with, and that they're going to go to trial.
Likely that they're not going to
No,
let
they're
up,
not gonna-
go all the way to trial. So
No.
there you are in trial, right? First court is to judge the facts.
Mhm.
And if the facts are on your side, then the judge has no other alternative but to rule in your favor. But even if he doesn't, then there's phase 3 to win on appeal. So if you're the person I hear you're declaring yourself to be, you're not going to quit. And so just so you know, we're going to be with you through all 3 phases if you want to be. But the first phase really sets the stage for all 3. And it's where all the issues of facts and all the issues of law are established. So work with us in phase 1 and know that we will stay with you all the way through phase 2 and 3.
Okay. Thank you.
Thanks, Susan. Yeah, amen. It's our time. We Americans, we have to stand on something other than might makes right. Okay, Monique.
Okay, so I'd like to take this class, and thank you, everyone. There's a few of you where I'm just amazed and so happy that you're here. I'm an at-will employee. The job I did so that I could do the arts, but I've been with them for 16 years. And Clint, you know what happened to me already, but my concern is because I am an at-will employee, that might be taken into effect where they say, well, the person who made the decision can make their decision based upon anything, so you really don't have a right. And I just want to make that clear before I go through the course expecting to win.
Yeah, it's not, you're not the only one who said it's in the air. People are saying that. I guess because defense lawyers are saying, "Oh, it's at will," but that's not the end of the story. It's not that simple. Go ahead, Zeke.
Well,
'Cause I went through the discrimination department already, so I've heard.
okay.
Yes.
And when you go through the discrimination, they ask us, what is your exception or what is your reason why you think you're being discriminated against? if you know you're not black, then you're not claiming you were black. So it boils down to a few, like that you can have medical exceptions, and we generally are looking at the religious exemption. Now, the religious exemption, they're saying, oh, well, you're secular, or you're this, and you don't have a religion. See, so we have to establish, and then they say, oh, if you're a Christian or a Muslim, well, they don't really believe not to take the.
It's more than that. It's a First Amendment right issue that
Okay.
happened with me.
Now, okay, so it's the First Amendment. So now I focus and say, let's assume your religion is the Constitution. Okay, and you strongly believe that we have to follow the Constitution. Now, the Fifth Amendment says they can't deny you your life, liberty, or your pursuit of happiness without due process. So you're saying, hey, I'm pursuing this job with pursuing my happiness. So I have a right to do that. They can't fire you at will if you are exercising your First Amendment right. However, they have fired you, but they may not and probably didn't give you your Fifth Amendment right. And that right is the right to due process. So we're going to break down this right in the class. What is due process? Because due process is fundamental to all of our country, to all of our nation. That's our religion, so to speak, due process. We're entitled to it. The Constitution grants it to us. So if we simply accept that as our quote unquote religious objection, now we're focusing on, were they prejudiced because they didn't give us due process?
Okay, it's a little bit more complicated, but I thank you for that, and I'm sure you
Yeah,
can help me.
We're going to break that
later.
down, yes.
Thank you.
All right, let's go to our next question with Leslie.
Great, awesome. Susan, go get them. I just have to say that, go get them. All right, I have two questions here. One, it's about discovery. A bunch of the emails that went back and forth around, you got the job, and now you don't because you're refusing to get the injection. I don't have access to those emails. So all of my facts would have to rely on their cooperation. I'm wondering, how that plays into the strategy. And then two, I'm also wondering if you're going to be offering this course in the fall.
Okay, let's take that first one. Discovery is very powerful. Tell them, Zeke, how we're going to get those emails.
Discovery is the way to get the emails, and it's simply writing the company, or more specifically their attorneys, and asking them to admit that they have those and that we want them to send them to us. And by law, by the discovery laws, they have to send it to us so we can get it. That's the method, discovery. And if you don't, we go to the court, and then we tell the court to make them give it to us.
Got it. Okay. All right. Thank you.
Yeah, and that goes with any facts of your case. Yeah, and you can look deeper too. You can get memos, you can get recordings, conversations. You can depose them. You can literally interview them and ask them under oath various questions in advance of the trial. We're going to teach you about just all the different avenues that you can use discovery. It is super powerful, and it can only happen if you file a civil suit.
Depose means deposition.
Nice. Yeah. So actually, that reminds me too that people have been asking about what are the anticipated costs above the tuition that you will run into. So relatively inexpensive, depending on your state. You'll have a filing fee that your state has. In California, I think, how much was it? Did you say $650?
$350, I think, $450 maybe now. $650 for federal, but
$650 for
could have
federal.
changed in the last 3 years.
Yeah, things could change. So there's the one-time filing fee, and that's for sure. Your court may charge a nominal fee, $20, $25, $30, $35 for motions that you make. And that deposition, if you do choose to institute a deposition, you will have to pay for the space where you meet, the person who records the conversation. You'll have to cover the cost of that. It's very powerful, and you might I don't know, you might want to do that just because you've been chomping at the bit to get them to actually hold still and respond to your questions and hold them accountable. I've heard a lot of stories and I'm like, I wish I could take that employer and put them in a room and make them answer under oath to these questions. So that could be very powerful. That's an option for you. Thanks for your question, Leslie. Let's go with Sean. Sean's back.
Lawyers are beholden to the bar, and as such, the bar can force them to comply within certain situations. And it appears to me that there's some bit of compromise depending upon which state you're involved in. And New York City and the Southern District is somewhat compromised. That said, that's a bonus for going it on your own, so to speak. You can also have the ability to be a little bit more naive, which provides you leniency with some of the judges if you're fortunate enough to get one that's somewhat decent. Aside from that, I had said to you, I just received a certified letter that just came from the DEP saying that you the opportunity to return to the DEP if I become fully vaccinated. Well, that's why I'm not there. So moving on from that, my question really comes down to this, is that with the information now that's coming out from Pfizer, where they've been forced to release documentations, and it's coming out more and more every month now, every 30 days, there's a larger data dump that's coming out. And individuals like Dr. Naomi Wolf, and there's a whole slew of people, and including Attorney Mr. Rents, or Attorney Rents out of, they're filing through all this stuff, and there's more documents and proof that the experimental mRNA gene therapy drug is extremely hazardous to your health. It doesn't help. It's zero efficacy. And I've had these people admit that that it's not they were of the belief that it was FDA approved, and it never has been. I'm curious as to, I filed a notice of claim. I plan, now that I've received my notice of claim was for wrongful termination. I plan on filing another notice of claim for this if you've become fully vaccinated, opportunity to come back to work. That's a separate discriminatory claim, I think, that I would like to file. I also want to file against the union for non-proper representation or failure to represent. And the question then now for me becomes, I think it'd be on a strategic standpoint, for me personally, waiting might be better than to act immediately, because because I don't see that, because of where I'm located and whom I'm, and the people that I'm going up against, it would be beneficial. And I'm just in a position now where I can afford to wait, because of my employment status has changed, and I'm able to, I want to proceed forward, but I don't know that pulling the trigger now is the best move. And I'm trying to figure out, like it's like a barroom brawl. You don't want the whole gang to come at you at once. You want them lining up through the door so you can knock them out one shot at a clip, as they're coming through the door. And I want to stack them up and knock them down. I don't want to have them, turn me into a kick circle. So that's my concern.
Yeah, it sounds very interesting. And you decide when you're going to file that suit. But once you file that suit, that initiates a whole bunch of things, right? So what do you say to him? Do you have any help for Sean?
Yeah, we would have to strategize. And, we would go look at it and see if it is better or not. He makes the decision. We help him strategize.
All right. Thanks.
And then there was the one question that was continued before was, will you offer the course in the fall?
Thanks for catching that. I was just reminded. Thank you.
Okay.
We don't have any plans right now other than this first phase. We're 100% focused, taking up all our energy. It will be recorded and as a package if people want to do it that way. But in terms of real-time clinics, in-person real-time clinics, this is the only one we have scheduled right now. All right, Sean. Yes, I love the way you look at things, because but again, you're the one who goes after them. They have to respond when you decide it's time for them to respond. All right, Helene.
Hi, thanks.
Uh-huh.
But I'm Jewish, and I am aware that most of the Jewish leaders in the country don't support not vaccinating, so they want Jews to get vaccinated. And my religious exemption that I filed with my employer, which supposedly I'm still employed, I'm still on unpaid leave, and this has been since October. I've never received any formal termination from them.
Terrible.
Anyway, so I submitted the religious exemption based on Judaism because that's my religion. However, most of the Jewish leadership thinks opposite. So is that a problem for me to have a case being a Jew when I think you'll find Zelenko, right? Dr. Zelenko, he's Jewish. She's for all the Hasidic rabbis. And now all the Hasidic rabbis are saying, don't vaccinate the kids. But none of the other groups of Judaism are.
It's a great question. It's not Jews. It's not just Jews. I think Zeke was talking about, Christians and Muslims and all the categories, all the different world religions. But what do you say, Zeke?
Well, I can say that I was raised Jewish. And then I came to a point where, from my understanding of law, I got an understanding of who Jesus was. And so then I could say, well, I was a Christian. And my little sister says, oh, no, once you're a Jew, you're always a Jew. And so I now introduce myself as a constitutionalist. And I can formulate that. I can call that my religion. And then I can say, I strongly, firmly, sincerely believe that I'm entitled to the Fifth Amendment of the Constitution, that I can't be denied my life, liberty, or property without due process. So if you're going to deny me my job that I'm pursuing happiness with, I get due process. So now I look to see, did I get it? I determine if I got it by looking at my understanding of what due process is. I know it's a notice and a fair hearing, so they need to show me the notice. And then when I go to the fair hearing, that's where the facts come in and how they adjudicated the facts of my case. And if they said that they got rid of me because of some reason, then I say, well, then let's see if it matches up against my right to have due process. And you can't deny me just for some reason if that reason is prejudicial against me.
So now you're a Jewish constitutionalist, okay?
I'll tell my dad, who's a rabbi, that too. I think I'll have a
Jewish
good laugh.
constitutionalist, a Messianic Jewish Jews constitutionalist.
Oh, is that?
Well, you can get labels or labels.
Yeah.
Yeah.
You don't want to get a label.
Yeah. Well, the other thing that really is frustrating is that I can't even send my kids to overnight camp because they are requiring it at Jewish summer camp.
Well, you can sue them as well.
Now you're
I can
going
sue
to
them as well.
Indeed, absolutely. It's wrong for people to do this.
Yeah.
It's out and out wrong. And so we have a solution for you. You sue them in civil court and you make them say out loud on record all of their crazy reasons why they're not being prejudiced when it's so obvious they are.
Exactly.
Okay.
Yeah.
So join us, Helene. We'd love to have you.
All right. Well, I'll need to get some chutzpah from you guys because I'm kind of scared to do all of this stuff. So
We got extra chutzpah. I think we got plenty.
Yeah, it's been all over here. Yeah.
all right. Thank you.
Yes. We have Nelda now.
Hi again. So yeah, I appreciate you mentioning some of the filing fees, and I don't know about everybody else out there, but I'm in dire straits right now after having been unemployed without income for a year. You mentioned the affiliate program, and I'm wondering if I can get a couple people to sign up over the weekend. Would that count towards my tuition?
Absolutely. For anyone who registers, I will send you an affiliate link that allow you then to turn around and share it with others and get compensation for that. It's going to be 35%. So again, if you get 3 people, that covers your tuition. And that means it's 30% of whatever the tuition is. So if it's by Monday, it's still 35% of the reduced tuition. Does that all make sense?
It does. It does. Thank you. I appreciate that.
Yeah, and if you want, send me an email. I can coordinate with you. I can strategize with you about best ways to help get this information. There will be the recording of this session, which will be online, and that will be a great way to send it to them and ask them to watch it and talk them through it.
All I have to do is talk to a couple of my friends.
Yeah.
Great,
Okay.
Nelda.
Thank you.
I have a quick answer for Nelda also, that there is a form that you can fill out in the state or federal courts that's called Informa Pauperis. And if you don't have the funds or what they call income, then you can file for free.
Great. See, we're going to use their
Thank you.
forms to our advantage. Yes. All right. Trisha's here.
Yeah, I think I'm gonna need some help sorting through mine because I'm an independent contractor and I mean that one of the jobs was it's basically two different jobs, but one I worked at 2 different facilities, and then there's the company that owns the facilities, and then there's the rehab company that contracts. And now the rehab company owner now is the CEO over, that happened after all this started, but she's now the CEO for the nursing home, you know, like the Renew, which is the nursing home owners. Anyway, so yeah, I'm gonna need a little bit of help like figuring all that out. And mine is also like, one, I was fired for not wearing the mask, and the other one I was fired for not filling out either an exemption or a vaccine card. And then the other company is separate, and it's pretty straightforward, I think. But
In these civil suits for wrongful termination, the statutes are very clear. They're very well used, and we can just walk in the door and get our case heard. And
Yeah.
so, all right, Tricia, thanks so much.
thank you.
Bianca, hello.
Hello, greetings everyone. So first of all, I would like to thank you so much for all of you do. And I am very interested in your course and definitely would like to take the class. Sorry, hold on.
Bring the baby.
First things first, right? We're all doing this for the children. That's a good reminder. You know, you hear that baby just born doesn't know about any of this stuff, but it's going to be growing up in a world that will either be more free and more just, or the opposite.
I'm very interested in your course and definitely would like to take the class. I'm curious if this is similar to Dr. Graves' jurisdictionary course, because I definitely is worth it. It's so awesome, and it would be helpful to learn more or beyond it.
Yes. Yeah, great point. So I was mentioning earlier is the different alternatives that you have to choose from. Dr. Graves' course is great. I recommend it. I am a student of it myself. I will personally be bringing the distinctions of that course into this course. It's when you take that course, you realize it's not hard. It's simpler than could be imagined. But yes, indeed, if anybody wants to take an online course that is unattended, that is self-directed, and it doesn't come with any coaching or any group or any one-on-ones at all, then I recommend How to Win in Court Without a Lawyer by Dr. Frederick Graves. And you can go onto our YouTube channel. You can watch the interview I did with Dr. Graves. It's fascinating. You get to hear about his story, how he came to be a lawyer after being a blue-collar worker for many, many years, and how he saw the corruption and just the lack of morality in the legal profession. And he determined that he was going to help people, just like the Commoner Law Group does, empower people to take their legal matters into their own hands. The difference with our course is that you get the real-time coaching that you need, like these 2 months. Take me, for example, I bought the course, 6 months ago or so. And now I have to renew if I want to have access to the material. But your choice to say, I'm going to do it now. Now is my time. And this is the structure that's going to support me and moving through all of the questions that I have, the obstacles that I run up against. And I know I'm going to get that support to get me to the finish line in quick order.
That is great.
That's a full answer, isn't it?
Yes, yes, it is. It's awesome. Thank you. Yeah, because I already it's been a little bit over a year, and I got an email from that and saying that I need to renew. So yeah, I need to take that course again as a refresher. And yes, so I'm glad you mentioned also that you're gonna be basically walking us through and guiding us with preparing the lawsuit from start to finish, basically from filing a claim to filing motions, writing a summary judgment, filing service process. Now, my question is, would you also be showing us how to do a bar grievance and all that?
That's, in all of our discussions, Zeke and I designing this, we didn't talk about what it might mean to hold accountable bar lawyers who break their own rules. But I don't suppose that we don't need to eliminate that. It's not squarely within our course at this time. But what do you say, Zeke?
I was typing in the chat, and I wanted to tell you, some of the people I can't chat to. So,
okay, so we'll just read the questions from chat. We'll just read them and answer them.
She said, thanks for the amazing information. The person who hired and fired me is a former best friend, so I need to really think about what I want. Is it just an apology? Also, am I curious about will you offer this in the fall? And see, the unique situations never stop coming in. And you have to realize, and it's a good point, because a lot of the lawyers that go against each other are very good friends with each other. So it doesn't matter, and you have to determine if you want an apology. And really, an apology, it's not worth filing fee, going to court, putting all this in for an apology. And then if you don't really want money, it's a personal thing. Just go and ask them, I would say. So,
yeah.
Okay, now I did hear something about the attorneys here in this question.
Well, it's just, what was it? What's called a bar?
Yeah, about are you also going to be showing us how to do bar grievance? Because I'm pretty sure if we're going to file a lawsuit against these companies, against the actual man or woman, the CEO, definitely they're gonna take this to their lawyer because they don't know what to do. They don't know how to answer it. So now in turn, we're gonna receive letters from the lawyer. Now are we gonna be guided as to how to do the bar grievance? We're basically gonna fire them.
Well, generally we're not gonna do that. The bar grievance. We're going to be friends with their lawyers, like I just said.
Okay.
A lot of times, when you talk different cases, lawyers, I've talked to lawyers, and they a lot of times give up their position. And they don't know, and I've helped lawyers to focus on their issues, because a lot of lawyers don't really understand law, but they know the process, and they're just interested in getting the client through and going to court and moving through the next one.
Right. Yeah, I get it. That makes sense. And then last question, will there be templates that will be provided as well on the class or the course?
So that's the interesting thing. Yes. Today, we don't actually need to write documents anymore. We were describing to you how advanced these court systems have gotten. They've automated everything into forms. Like everything you can think about has a form attached to it. But when it comes to, for example, your cause of action, your allegations will be the meat of that form. So you'll fill out the form and you'll put the allegations in your own words. So in that way, we don't have to have templates like we've been used to using in terms of the formatting and all of the different pieces in it. The form takes care of it. In fact, it's quite a convenience For example, I was going through the one in California, and one of the first questions it asks, you know, runs you through a series of questions. One of them is, do you work for the federal government? And they ask you that question because if you do, then you need to take a separate pathway. So I put no, of course, and then so it gave me the form that was appropriate for me, someone who doesn't work for a federal government. So all of these questions kind of get automated, and they've made that easier. We're going to help make that easy. That helps you focus on the issue, which really the everything rests on, what the meat of the matter is.
Oh, wow, that's great. That's awesome. So you mean to say it's like pre-filled, and I mean, yeah, kind of like a pre-filled format. And then say, for example, in my state, Arizona, it would actually say the Arizona revised statutes and codes as well.
That's what we'll do in the first class. We're going to get people online because every state's a little different. We're going to help people get to the form that they need. And then you'll see it. For example, it'll say, what was the action that the other person took? And so you put the facts of what they did, you know, and then they'll ask you, okay, well, what was the damages? And then you write what that was in that field. And there's a lot of other checkbox, like the date, time frame, what date, what, you know, it's like, it's all thought out, and not every state's the same. So we'll find out. I actually meant to ask Zeke, but I'm pretty sure that if it comes to it, that for some reason your state doesn't have the form, which is unlikely, or the forms just don't, for one reason or another, work for your situation, we can help you craft an actual, you know, document from scratch if we need to. But we're actually, doesn't even look like we need to.
Yeah, that's awesome. Thank you so much. I mean, I do really appreciate you guys. Thank you.
For sure. Wonderful to have you, Bianca. All right, now, Odessa.
Yes, thank you. So my follow-up question to earlier, because I don't understand how to navigate this situation since I'm not fired, I was placed on leave, and now they're inviting me to come back and telling me, basically, according to what you said, how to sue them. I have no idea how to navigate. Is it considered me not taking, not wanting to take the job? They're trying to resolve it now. So if I don't schedule a meeting with them, will that look negative to my process and me continuing my process? Or should I even say yes to the meeting and go in and go back to work while I'm still attempting to follow this process?
I see Zeke just nodding his head. I'm curious about what winning looks like for you. Did I already ask you that?
Well, winning looks, I really don't care to go back to that job, but they are now seeking remedy, saying, okay, come back.
With any financial compensation for the trouble?
They are not saying anything. They just want me to set up a meeting. And I'm like, okay, I'm kind of doing this process.
You don't want the job, but what do you want? What would you want? What would you, after everything you've been through, everything they've done to you, all of the emotion and uncertainty and roller coaster that you've been through, what would you, as you sit there today, what would you be satisfied with? What would make you whole?
I would be satisfied with the compensation and not having to go back to campus.
We'll take you through a suit that asks for those damages based on the facts of your situation, including this rigmarole. To me, that sounds like a rigmarole that they're trying to avoid. They're trying to avoid you suing them and winning for a large number. I don't know. What do you think, Zeke?
Well, okay, and this is exactly what we're going to do. So he asked you what you want. Now, I would go to this hearing, meeting, and I would negotiate exactly what you want, but I would not tell them that you're going to quit or you don't want the job. So once you negotiate, this is the whole negotiation. This is your case. And you tell them what you want, how you want it, then they'll say what they want, you'll say what you want. And then, but you don't tell them you're going to quit or you don't want your job. So once you get your job back and once you get what you want or enough to get to where you want here, then you can take action to get compensated or what have you. So go in negotiating as if you want your job, because you can always quit it the minute you get it. So you want to get what you want. What is it you want? You want, if they say, okay, we'll hire you back, you say, okay, well then pay me back wages and this and that. And if they say they're not going to, then you'll have to file a suit for the wages that you didn't get and determine if it's worth it. You know, you go through the whole process and you asking yourself, and this is what we'll do. Just decide what you want, go for it. Don't give away all your cards, and then just figure out what you got in the hearing and then proceed from there.
Okay, great. Thank you.
Yeah, that's why we included in the first part of the first phase to have a meet and confer with your employer one more time. Either they may not want to meet with you at all, but if they do it just as Zeke did. You put forth what you want, they'll put forth what you want, unless they're willing to totally give you what you want, but otherwise they're basically, in other words, saying, okay, go ahead and sue us. And I want you to get all of that. I don't want you to go back to a job that you don't want. And they haven't confessed their sins. I don't know how to say it. They're not at all willing to admit that they've been prejudiced towards you, that they've been treating you based on their religion. They've been treating you badly.
They never will. They never will until the day before the trial.
The day before the trial, right?
Yeah, I mean, that's
moment of truth.
Yep.
Well,
Push it all the way.
Speaking of sin, sin is CIN, sin.
I'm sorry, mine is a very different format, and I wanted to take your input, Zeke. But so I'm acting like a mama bear. My daughter works for a private big company that has federal government accounts. So they were requiring something, and I found a exemption form. She hated the language, she adapted it, she put it in, and she's been fine so far. But I see the writing in the wall. I'm like, sooner or later something's going to happen, so I'm trying to be prepared ahead. I just don't think that this course, or I'm not sure this would be a good place for me to start learning from what I'm learning. And then I'm like, I didn't even know there exists private attorneys. So is that what you consider yourself, Zeke?
No, I don't consider myself an attorney.
Pardon me?
I don't consider myself an attorney. I've been studying law for 40 years. I usually put my mind in the place of the judge, so I can see both sides. And an attorney is really just someone who brings the case, puts the facts down, and argues and makes the argument. So in our situation, it's going to come down to our argument of that we were being discriminated against, they were being prejudiced because of a statutory statutory right that was given to us. We have a right not to be prejudiced if we're Black, if our race, our creed, our color, our medical condition, and all these things are already listed out. And we pick the one that we think we fit under, and that's where our kind of argument goes. Remember, because we see that if we claim to be a Christian or we claim to be a Muslim or any of the religions, then they've just twisted that around. So we're now seeing that. So we're going to focus it a little different, because words can mean a lot of different things in a lot of different contexts. And that's kind of the important thing about understanding law and procedure.
Right. I meant, when I said attorney, I didn't mean an attorney by bar. It's just that I heard of these people acting as private citizen attorneys.
They're acting, it's called the private attorney general.
Private attorney general. But
yeah, that's another class.
Totally different. Okay.
Yeah.
But yeah, I can see this happening already, because one of the things that her exemption was accepted, but now to further herself, she has to go to these trainings where they meet once a year in Florida, of all the places, right? And they're requiring them to show a vaccination card in order to participate. And so if they don't participate, then they're not furthering their career. You know, so it's kind of very,
Yeah, absolutely. I want you guys to relate to Zeke first and foremost as your friend. You know, that's why I'm so proud and pleased to partner with him, because in Zeke, you find the perfect combination of somebody who's been there and beat his head against the common law principled, like outside the system stuff. And he lived it with his family for years and they've experienced it. They gave it the good old college try. And yet he was committed to finding a way. And so when he learned all of the statutory procedures, he discovered that you can get into the system and still fully express your constitutional principles. There's once you get in, then there's room for all of it, but you have to get in through the doorway first. And on top of all that, he literally cares. He's one of us. Do you know what I'm saying? You talk to lawyers, talk to Dr. Graves, who I love, I have a lot of respect for him, but because he says it, because I'm a bar certified lawyer in the state of Florida, I cannot give advice to other people out in other states without risking my bar license. And so we're dealing with Zeke, who's here as a whole person, as a whole human being. He doesn't have any limitations. He's not afraid of being sued for practicing law without a license. He's not afraid of giving advice. At the same time, folks, a friend doesn't give you advice, right? All the time. I've learned. How about you? That when your friends come and they tell you about the problems, sometimes giving advice can work. A lot of times giving advice doesn't work. So what we're going to be doing is giving you information. We're going to keep you empowered. We're going to give you pros and cons. We're going to support you in the choices you make. And if you really, really want to just tell me, what should I do? You know, we'll probably say, okay, do this. But then even if we say it in those terms, we all know it's your ultimate choice. And you're the one whose expression, this is your expression, this is your opportunity to stand up for your rights. And Zeke gets it like as much as any of us. He's one of us.
And to
So-
break that, oh, excuse me.
what
to
would
break
be
that,
the best thing for me to start off with? I mean, I'm at the point where I want to back off of having a driver's license and all these other things. That's my point, but I need to learn. So I'm kind of wondering, where do I go? I mean,
you're going to come to this course. I'm telling you where you're going to go. You're going to go right to this course, and then you're going to have a little bit of time with me. And because of what you just said, it's going to determine how long it's going to take me to get you to understand what's going on in reality in life. And this because I did exactly what you said. I got rid of my driver's license, and that's how I got on this whole path. And we have to discuss it because you have myths in your mind. And how long is it going to take me to pull those out of you? Because the stronger your mind is and the more focused on what you believe is, the longer it's going to take for me to pull it out.
well, I'm even worse off because I'm confused because I was raised outside of the United States. So I'm under knowledge of Napoleonic code.
That's okay.
It's
No,
very different.
yeah, well, we're going to have to talk. We're going to have to talk. And I think I can turn you around pretty quick.
Yeah.
And straighten you out.
For learning without having a specific case, I'm just learning.
Yes.
To be
We
prepared.
started without a case, studying.
Yeah. Okay.
Yeah. And again, that's what I was going to tell you is the words when Clint, if we're going to, you know, oh, Zeke's giving us advice or this and that, we all say this, but if it comes down to a technical legal court and they ask, well, I'm giving assistance of counsel.
Mhm.
That's the technical, but I don't have a problem throwing it around advice and things like that because they're going to say, they can say what they say, I can say what I say, but when it comes down to in the legal process, I'm giving assistance of counsel, and everybody has the right to assistance of counsel. It's in the Constitution.
So how are you getting past? I'm in one of the worst counties, Santa Clara County. So,
I know.
how do you get past going into court? Because they won't let you in without these requirements. Without
What requirement?
Masked and vaccination.
Oh,
cards.
okay. Well, we have to discuss that because in our mastermind, we had people that had to deal with that, and some of them couldn't. but why do you want to go into court? Oh, they're kicking
Right.
us out. Okay, well, then we won't go. But they put up Zoom and there's options, and we have to be flexible also.
Okay, okay, thank you.
Mhm.
Wonderful. Yeah, Zeke is a wealth. Every conversation we have, I learn more about what he has to offer. So we're actually crafting other courses, including right to travel stuff, how to get out of traffic
Yes.
citations.
Mhm.
That's
the one I want to teach. That's
Yeah,
the one. Yeah, for me.
He's figured it out. He has
That's what
figured
I
out.
want to do.
That's the one I learned on 40 years.
And then there's the old IRS that
Yeah, that too.
sits there as the elephant in the room as well. So, look forward to more courses from Zeke and I. We just want to support people in holding their employers accountable for the terrible things they've done. And yeah, it'd be great if you don't necessarily even have to be in the situation to join the course. You can still learn and even be of support to the others who are really going through it.
I have a question about the course real quick though. I know Rick who started the constitutional law group and he did exactly what you said, Zeke, and he was arrested for I think 30 days or whatnot because he doesn't have a bar license.
He said what I said?
Yeah, I mean, he was giving assistance to counsel, I gather, or he she didn't have a lawyer, this woman. She owned a restaurant. This was in a state up north. So he was helping her.
Mhm.
Then he said that he was helping her with the language. Anyway, look it up. His name is Rick Martin. Really nice
Okay.
person.
Well, I can tell you that it's a very technical thing, and I've gone through it 2 specific times, and I can tell you the difference between me and him because they quit trying to come after us for practicing law without a license in the 80s, but we don't practice. We don't go in and represent somebody. We assist, which means we don't talk to the court.
I see.
Okay, I don't talk to the court. I help the person I'm next to. And I got a couple good stories about that. If you sign up with the class, I'll probably give them.
Okay. Yeah, I don't think he actually assisted in the courtroom, but
Yeah, I don't
helping
think
this
he
woman.
had. And
Rick
I know
Martin.
about this guy too.
All right. So
I know about
anyway,
me.
regarding the question, the times, what are the times again for Tuesday and Saturday?
Sharing in the chat an interview we did with Rick Martin.
Do you know what I'm talking about, right, Clint?
Oh yeah, he's awesome. And I do know something. This is our Don't Fear the DMV course. He was a special guest on. He's quite a character. The thing is, we patriots, if you want to use that term, have to be prepared to go to jail sometimes. That's not the ultimate horrible thing, because they use intimidation, including up to and including incarceration. They will push their limits. They will arrest you even if they don't have a case, put you through the ringer, so to speak. Yeah, you can make yourself a target. And I think Zeke is he's definitely acting responsibly and he's acting consciously and he knows what he's doing. So we appreciate the warning, and the future is the future. It'll be what it'll be. We're not afraid.
Yeah, I think he's gained some money because he has been treated illegally. So I don't know. Anyway, but the times for the class.
So Tuesdays, 4 p.m. Pacific, Saturdays, noon.
And what if it goes longer than, what is it allotted, 3 hours?
We have 2 hours for each one.
2 hours for each one.
Mhm.
Okay. There was also a comment that someone had made with regards to companies looking into if you've ever sued another company. And I know that it's illegal if they retaliate on you, but from firsthand experience, I had auditioned for a reality show and they wanted to know if I had ever sued anyone. And now that you're saying that it's illegal, well, you didn't say it was illegal for them to ask. I'm presuming maybe it was illegal for them to ask. I don't know. You could get into it some other time,
Yeah,
but
we'll get into that. Yeah.
just putting that out there.
Wow, interesting.
Good point.
They're trying to find out, are you going to hold us accountable if we screw you over? Is basically what they're asking.
Yeah. Okay. Thank you.
You're welcome.
Thank you. good points.
Yeah, I remember last, Monique, when you were on, folks were like, get out of Hollywood, just leave. It's a den of iniquity. You got to get away. All right, Cindy, did you raise your hand one more time?
I
Love to-
sure did. I do have another question with you, how you're going to handle it, because it seems like Pfizer and the other guys are pushing for this birth to certain age for vaccines in order to comply so that the vaccine will no longer be hailed as a, what do you call it, experimental. So it will lose its experimental status. How are you going to be handling that from then on?
Well, the thing is, Zeke is going to show you over and over again. He's done it with me countless times since we met. He's going to eliminate the things that don't matter, and he's going to bring you back to the things that do matter. I'm like you. I study all this stuff. I follow stuff because I'm a health freedom advocate, and I want to know what the big picture all the time and what's happening. I've been, and that's great, but a lot of that information is, frankly, not relevant. But yes, in general, the tide is changing, and they're making, in some ways, they are making inroads, and at the same time, we are also having our victories. It's not over at all, and I do pray for those poor people who happen to take an injection that has something in it that's not good for them, and they suffer from it. That's something I would like to avoid. If I had a way, a magic wand, I would do that right now. But in the meantime, the facts of your case are the facts of your case. And what happened with your conversations in your company, on real dates with real facts, that's really what we're going to be focusing on. All right, Sin, thank you again.
Thank you.
All right, folks, I don't see any more hands up.
Okay, I
Monique.
don't want to take up all the time, but I do have more questions. So what if you have an attorney who's interested in representing the group, as I said, like the mass tort? Are you able to double dip, or probably not? But I guess it doesn't matter. That this is a great course regardless, but I'm putting it out there.
Hey, we'll entertain anybody that wants to offer we'll entertain any offers. We're open to listening. We accept everything, and then we'll determine if we want to negotiate or we want to reject it.
I see.
But
Okay.
we listen to everything. We a lot of garbage, but we listen, and then we separate it out. So yeah, we're open into an attorney coming in and telling him how he's going to help us, because we learn stuff from attorneys. We learn a lot of things from everybody in this here. Even here, we've learned so much. People have these situations, and they're telling it. And I'm learning. Oh, wow, that one. And I'm thinking, oh, well, I do this, I do that. Okay, this. Oh, he's got that. I mean, I'm learning all the time how to formulate. So yeah, we're open.
I meant, would I be able to go with the group and also sue those of the people who were,
Yes, you can go with the group and go with an attorney, and you can tell us what the attorney's doing, and we can learn from that, and you can decide if you want to make your own suit alongside the group. Yeah, the options are all there.
and if you have the organization and there were multiple people that did various illegal acts to you, do you sue them individually? Those?
Yes, they're separate. If you got a ticket, you're dealing with the cop. If you got something from the IRS, you're dealing with the IRS. They're separate. Yeah, you're dealing with however they come in, you deal with it.
Okay, and last question about the course. You said 2 o'clock on Saturday. Sorry, was that Eastern Standard Time?
Noon Pacific. Noon to 2 Pacific for, you're in California, right? So it's noon to 2.
Right now I'm at my mom's in New Jersey, so I'm on Eastern Standard Time.
3 to 5 on Saturdays.
3 to 5 on Saturdays, and on Tuesdays,
On
Eastern
Tuesdays, it'll be 7 to 9.
7 to 9. And do you recommend doing the 2 days per week to get that extra support? Or is it
It's designed for. Exactly. To have more time to hear other people's situations that might help you with yours, and to ask questions during the Q&A of Zeke. Yep, that's the point. That's the point of having the 2 times, because sometimes, because you know right away whether yours is pretty vanilla or it's not so vanilla, in which case the Tuesday and Saturday options for you.
And you can, are you going to throw new things in, like on a Saturday that you wouldn't talk about on a Tuesday per se? Or I know no 2 classes are exactly alike.
Right. Well, they'll be recorded. So yeah, things will come up on Saturdays that don't come on Tuesdays, but they'll be all recorded. So, and made available. So whether you sign up for Tuesday or Saturday, you'll get both Tuesday and Saturday recordings. Just the additional advantage of being in both is that, yeah, you get more exposure to the conversation. You might get some repeat, but then you also might get some new stuff, and you'll have more chance for Q&A with Zeke.
And your time limit on people explaining, because there are complicated situations and we don't want to take advantage of everyone's time. How do
you think I've done so far? You've been with me a few times. How do you think I do?
I think you do very well. I just want to make sure, because I don't want to take over.
If I have your permission, and I'll ask everyone's permission, can I cut you off if it seems like you're...
Don't say cut me off. You could use a better word than that. Okay, thank you.
I'm not going to interrupt, draw your attention to the time passing.
Thank you.
Things. Yeah, it's basically, I'm a professional interrupter is what I say. Because yeah, I mean, I too want to hear the whole story, but I know we have a service to provide, and so I definitely will be the crispy, stick to it guy. You can count on that.
All right. I just want to make sure I get it all out there without using everyone's time. Thank you.
You're welcome. And we have email and other ways too, and we'll have the discussion group. So you can pose your questions to the group throughout the week, thereby telling your story or honing your questions, so that when you do get to the sessions, you'll have your questions much more focused. But we understand if you're not focused, we can help you get focused. That's one of the services we provide. All right, Susan Richardson.
Yes, so it's me again. So I'm talking to my husband. He's actually on the phone listening to the rest of this Zoom with me. And we're talking because, like I said, he still works for the company that I was terminated by. And he's a little nervous that he doesn't think that I can't do it, because he does know me. However, he is not confident in the idea of me going against this particular company. Now, I don't know where you're from. I live in California. I used to work for BART, Bay Area Rapid Transit. And if anybody knows anything about that company, they are not nice. They don't want to give up a penny. So he's a little nervous about the idea of me doing this alone. He would prefer that I stay with the group, and I prefer to stay with the group too. I don't want to leave this group, because we have supported each other through this awful time. However, we have 2 attorneys that we're looking at. So he feels like, you're probably better off winning with the attorneys versus if you just kind of stray away and do this on your own. So what information, and he can't hear you, so what can you say to him that could, because I am married, so I can't,
I get it. You guys, it's a joint decision. I totally respect your joint decision. You are a couple, you're a unit. I understand very much. But did I read between the lines that he was at all worried that let me just clear this up real quick. If you sue and he still works there, that they might retaliate against him in some way?
No, that's
okay.
Not.
I just want to make sure that wasn't the case. So you're just talking about whether to go with lawyers or just to get to it right now yourself, quick.
Because in our minds, we think that these attorneys will represent us better than we will represent ourselves, because lack of knowledge. Let's just say that, I guess.
Exactly. Well, your lack of knowledge is their paycheck. They use your lack of knowledge and they exaggerate it. And they want you to believe that they are so much more proficient and that you are just not, it's above your pay grade. Don't even think about it. And what we're talking about here, a lawsuit for wrongful damage is based on prejudice. And I'd love to learn the facts of your case, because you could have any number, you could have more than one cause of action, considering, I forget, you said something about your story already, but the point is, it's really straightforward. It's not complicated. There's not a lot to know. And what matters is that you initiate the suit, get it started so that they have to respond. Because until then, you really don't know what your employer has as a defense.
Right.
And the lawyers could speculate and tell you this and tell you that. And I understand that that's their hustle.
And what I would say is that when you come with us and take this course, you don't have to do anything. And I think that you take this course, you learn a lot, you'll be able to watch what your attorneys are doing, and you can possibly learn something that can help your attorneys, believe it or not, in this case. That you can add value to them from what you learn just by attending. We're not going to say you have to do this, you have to do that. You're free to do what you want. And at any point along the way, you can decide, do I want to go by myself or do I want to this? But, you know, it's just an educational thing. So I'd use it to your advantage.
All right. Husband?
Gee, keep those lawyers on a short leash.
Okay, so he said, thank you guys. We're going to discuss it, and hopefully you will see me shortly.
Yeah.
Okay.
Yeah, yeah, the price is a household price. So you two can share the curriculum together, and that's true for everybody. Okay, everyone here. That means if you're a couple, okay. Again, I'm blessed to be with you all. The quality and caliber of people who have attended tonight, it's amazing. I'm just so happy to know you all and to be in company with you. So I hope that this time was valuable for you, whether or not you choose to join us, that at least the time that you took to be with us is valuable to you, that you're better off, so to speak, than when you first got here, that we did some service for you. We're here to provide a service first and foremost. We have an objective that you get what you want. When you say what winning means to you, that's what we want for you, is to win. Of course, with integrity and honor and all that good stuff. With that, everyone, Zeke, let's send them off with some blessings and see them Tuesday and or Saturday.
Okay. Thank you, everybody.
All right. Goodbye.